Stay is continuing against the bank. Since June, stay is continuing against the bank.
I primarily Monday.
We'll see that.
Obliges.
On criminal appeal for bail, the accused inside custody more than tail.
Milord, item number 5 may kindly be permitted to be withdrawn with liberty to file again because some more important documents are to be filed.
Are you filing any memo? Please file a memo. Withdrawal memo.
I am filing within
Mr.
5
Pramod Kumar
minutes.
Ghosh files a memo for withdrawal of the writ petition. You say you want liberty to file afresh or don't want liberty?
No, with liberty to file again.
Liberty to file afresh with since some relevant documents are to be filed and some new
Pleadings to
readings will be taken. Accordingly, the institution disposed of this. Memo is taken on record. Please write the memo and
yes, just now I am obliged.
Item 8.
Yeah.
Pursuant to my lord's direction, my friend is now serving a copy of the collector's order. It will require the read to be amended. So 1 week time. Just now I am receiving. Not yet
serving the copy right now.
So Union of India, who is appearing?
Union of India has no role, my lord. It's the state government. The
So
state project.
who has filed and what he has filed?
They have filed, the collector come arbitrator has passed an order.
Okay.
Therefore, unless the writ is amended, writ petition is amended.
No, let us see the last order.
Yes, ma'am.
Item number 8 is WPC, okay.
24158.
That is the order dated 6/11/2024.
My lord.
Please read it out.
611.
Yes. It's order dated 21/10/2024.
That is the first order.
That is
Okay, 21/10.
yes. Then 6/11. I'm sorry, 6/11/2024. Learned counsel for the state submitted that he will serve a copy of the order dated.
Is that modem is working? Okay.
Yes, ma'am.
May I read, madam?
Yes.
Learned counsel for the state submitted that he will serve a copy of the order dated 9/10/2024 passed by the arbitrator from Collector Koraput as per the order dated 21/10/2024 by tomorrow. Learned counsel for the petitioner 6 1 week adjournment. Please this matter week commencing 18/11/2024.
So now that copy of the order has been served on you.
Just
Yes,
now.
today. Just now, because
Today.
Today.
And you want to amend the writ petition
Madam.
because of that.
Madam.
Let me. As per the order dated 9/10/2024 and 6/11/2024, the Learned Counsel for the state has already served a copy of the order dated 9/10/2024 passed by the arbitrator from Collector Koraput. The Land Counsel for the petitioners, after going through the said order, took some time to file an interim application for modification of the writ petition
For amendment.
for amendment, interim application for amendment, and its adjournment. List this matter in the week commencing. Let it come on 17th.
Madam.
Oh, sorry, that. Then let it come
20th.
20th January 2020 with the interim application, if any, filed by the Learned Counsel for the petitioners, copy of which shall be served on the Learned Counsel for the state in advance.
Your lordship said received today, my lord. Already.
As I received today, which you already received.
Obliged.
20th of January 2025. And Union of India represent for them, Mr. Pari, or Jahan Nasi Dehi, I remember.
Okay. Yes.
Item 26. Yes, what do you want?
Question to direction of my law. I have applied for certified copy of the lease deed below.
Just a minute. Let us see the order.
Yes.
Oh, the original sale deed.
Not sale deed.
It is
Lease deed.
Okay, lease deed. That you want to, that you have already applied.
Already applied.
And how much time you want?
At least one more time.
Land Counsel for the petitioner submits that steps have already been taken for the or certified copy of the original lease deed has already been applied for and some more time may be granted for producing the same. This matter in the week commencing from 3rd of February 2020. All right? Yeah.
No, no, better let the state council directly produce the lease deed.
No, no, no.
No, you said it.
Because no deed has been executed. And
then
also,
you
neither
have-
the act nor
You,
rules of
you have
provide.
already applied for,
Yeah.
if they, if you face any problem or they do not provide it to you, matter is different. You have already said that I have applied for. And why the state? It is your writ petition. All right, next. February 2020.
Weekly list, item number 1.
Last time, I directed the central government to take instruction.
Just read that order, 25/11/24. What is that, man? He was located for the
We don't have
Just a minute, Mr. Pari, just a minute. Did you get this order 25/11/2024? Please read it out.
As per the order dated 5/9/24, Learned Council for the petition filed the consolidated cost title, which is available in the case record. Copy of this has already been served on the Learned Council for the Union of India. Mr. P.K. Pahari, Learned Council DSTA, along with Mr. D.K. Kapchait, and CGG appearing for opposite party 2 weeks time to obtain instructions regarding communication, if any, made by the opposite party number 2 to the petitioner after she has given a personal hearing as per notice dated 8/9/2022 under annexure 5.
Yes, Mr. Pari, what do you say?
we don't have received any instruction by law till date, in spite of my repeated letter of notice.
What do you want? We will.
Another
personal
10 days time may be
appearance
given,
or-
otherwise let me pass necessary.
You want we should direct the personal appearance of that opposite party number 2, or you will do the needful?
I will take another chance, my lord, for 10 days time may be given, otherwise let me pass necessary order. Let me reflect also, if they are not giving, then the officer will appear in person.
Mr. P.K. Pari, Learned Deputy Solicitor General of India, along with Mr. D.K. Gosait, Learned Central Government Council, appearing for the opposite party, submitted that as per the order dated 25/11/2024, they have already sought for instruction from opposite party number 2, but no instruction has yet been received. The Land Council for the Land Deputy Solicitor General submits that 1 week further may be granted in that respect. This matter will be commencing from 20th of January 2024. If no instruction is received from the opposite party number 2 in terms of the order dated 25/11/2024, will be constrained to pass appearance of the opposite party number 2 either through virtual. Yes, this matter 20th of January 20.
Item 2.
May I please, my lordship? The petitioners are the forest dwellers in Sundar Gopalpur village of Sundargarh district, my lord.
There is some report, Mr. Counsel. Have you gone through that report after the examination of the matter? It is found that it comes under the land acquisition matter, hence it may be placed. Okay. Yes, what's your prayer in this expedition?
My prayer is the payment of a compensation, my lord. May not be a land acquisition, but it is a conversion of forest land into non-forest purposes, my lord. And my name found place in the list submitted by the collector. Collector is the appropriate authority.
Where is the list of beneficiaries?
My lord,
Annexure 3.
Annexure 3, your lordship may see Annexure 3, page 31.
Yeah.
Item serial number 11, 12, 13, 14, and 17, my lord. This is a list submitted by the collector, and also it has been approved by the MCL authority, my lord. The plea they are taking now, all the persons have already been paid on my similarly situated in my footing, my lord, or they have been paid.
Mr. Das, one thing we just want, why so many petitioners have joined together? Because the amount may be different, the
amount, but this situation is similar, my lord.
It should have been separate. Petition should have been filed.
My lord, poor Adivasi fellows, they do not have any lordship.
Is it the same thing?
Same thing, same. It is compensation to be decided, my lord. Nothing more. Only similar.
And, have you paid those court fees, etc., extra court fees which you are required to be paid in case you file a joint petition?
That defect has not been identified, my lord. Dictated. I'll pay it, my lord. Lordship, direct, I'll pay it.
Whether they have seen it or not.
Well, the prayer is similar, my lord. There is the only payment of compensation.
You see, the extent of land acquired may be different. And
my lord, I have given a chart.
Compensation that would also vary, and in
that
some
may
cases
vary, but the compensation may vary. But issue is the compensation, my lord. Payment of compensation. They may decide whatever compensation to entitle the decided.
You see, Mr. That's why we're telling that in some case of the petitioner, they might not have any objection. In some case, they may say
no,
that
that's not the fact.
That is exactly why separate read petition should
my
have.
Lord, everything has been separately mentioned in this petition, my lord. Your lordship may see the representation I have submitted before the authority, and also the claim tribunal. Claim tribunal has already adjudicated in favor of others, my lord. We are also similarly situated persons, my lord.
So you
claim
want
tribunal now the criminal, my lord. I may submit one second, my lord. Now the claim tribunal says that we have no jurisdiction since the Honorable Supreme Court has passed order restricting us to.
Your annexure 4 is pending before the general manager.
No, that has been decided, my lord, by annexure 7, my lord. By annexure 7. Your lordship may one line order may pass directly the claim tribunal to decide my matter, my lord.
So claims tribunal now it is not functioning.
It is functioning, my lord, in respect of other villages, not in this village.
No,
it is functioning.
We are not. It was told that.
Now I have made the chairman. I have made the chairman. The chairman told if Honorable High Court will decide the matter.
No, High Court. The matter is before the Honorable Supreme Court, and some judgment is reserved in that we are told.
Then so Honorable Supreme Court in that order dated. I am placing that order, my lord. That is 71 of the. It is lastly directed that any fresh dispute on account of the calculation of compensation, disbursement of benefits, etc., would be adjudicated by Honorable High Court. This court will not entertain miscellaneous applications in individual cases in this regard, my lord. This is taking this plea of this order, my lord. The claim tribunal is not acting upon this on the other villages, excepting the 4 villages which have been directed to adjudicate.
You come to the annexure 7 series, which
annexure, my lord, annexure 7. My lord, may I read, my lord?
Yes.
Kindly refer to the letter under reference on the subject side. My representation. This is the outcome of my representation, my lord. Kindly refer to the letter under reference on subject cited above. The matter on the issue of payment of heir compensation for the above noted land has been inquired into details. In this regard, the Honorable Claim Tribunal Bhubaneswar has assessed and prepared the compensation role on village Gopalpur, which is subsequently approved by the Honorable Supreme Court of India. In the approved compensation role of the village Gopalpur, FRA compensation in your favor is not awarded. My claim is though my name has been recommended by the collector, and it has also been Mahanadi Coalfield has also said that this is to be awarded by the commissioner, my lord. Since commissioner is not awarding in my favor, they are not paying, my lord. That is their plea. And or in any civil case, you have been awarded FRA compensation for your above mentioned FRA quota.
Mr. Das, in fact, the spirit of the order is that it is the commission has already awarded, and that has already been confirmed by the Supreme Court. But
My lord,
your name does not appear.
my lord,
How can you say that it has not been adjudicated so far?
No, not adjudicated in the sense, my lord. I am coming to the another annexure, my lord. Your lordship may say, see, annexure 3, your lordship may see annexure 3 page 31, my lord.
Yes.
Page 31. My name found place at serial
Yes.
number 11, 12, 13, 14 and 17, my lord. Order from claim tribunal is awaiting. The claim tribunal has not passed, adjudicated our case, and other cases has been adjudicated. It is awaiting. In the meantime, claim tribunal seizes their power, my lord. That is the problem, no, or else we would have approached this claim tribunal.
This we are directing also the registry to make the fresh stamp reporting if any thing added post you are to fill.
My lord, I am running from pillar to post. Once it was listed before by the honorable single judge, and they said that this is a compensative land acquisition matter, but actually this is not land acquisition matter, my lord. And they fresh registry has made a fresh SR that thereafter it has listed before lordship. Now where to go and go, my lord.
No.
This is with regard to your lordship में direct the claims tribunal में to adjudicate my matter. It will look fresh special order for your lordship from your lordship so that they have said
power to adjudicate.
6324, these orders have been passed. Annexure 7 series, it has been passed on the petition dated 6/3/2024.
My lord, 30,
petition
30.
is 6/3/24 is the petition, that is annexure 6 series. It is addressed to Claims Commission, Bhubaneswar, and simultaneously copy has been given to GM Mahalakshmi area, MCL Sundargarh, right? Annexure 6 series starts at page number 56. On that Annexure 7 series, you will find in the top, the reference is your petition dated 6/3/24 addressed to GM Mahalakshmi area.
My lord.
So on that petition, this order has been passed.
My lord. My petition to the MCL authority has been disposed of with regard to the but my petition before the claim tribunal is pending.
This petition has been filed by 5 petitioners, namely Srimati Sukanti Maji, Sri Arakita Nayak, Sri Shahadev Ahmad, Sri Kalakar Pradhan, and Sri Sudhakar Ahmad.
All are of village Gopal.
With a prayer for a direction to the opposite parties to pay FRA compensation like other similarly situated persons as per the list submitted by the collector under Annexure 2 series. And for a declaration that the deletion of the names of petitioner from the list is illegal. And for a direction to the MCL authorities to pay FRA compensation with interest as per list submitted by the collector under Annexure 2 series within a stipulated time. The Mr. Das Land Council appearing for the petitioners drew the attention of this court to Annexure 3,
Yes, ma'am.
which is the administrative approval order for payment of compensation for forest lease land granted under FRA Act 2006 awarded by the Land and Claims Commission, Bhubaneswar, passed in different civil cases arising out of SLP C number 6933 of 2007, and submits that the name of the 5 petitioners find place in such list as serial number
11 to 14 and
11,
13,
12, 13, 14, and 17. Na?
17, my lord.
17. The in spite of the names of the petitioner being included in the list under Annexure 3, since the petitioner did not get any compensation, they submitted a representation inter alia before the uh, General Manager Mahalakshmi Area MCL Sundargarh.
My lord.
That is opposite party number 2.
My lord.
On it and two. With a prayer for taking necessary steps for payment of adequate compensation for the land in village Gopalpur belonging to the petitioners, which has been acquired by the MCL for coal mining purposes. However, the opposite party number 2 by order dated 33/2024 under Annexure 7 series has informed the petitioners that the matter on the issue of payment of FRA compensation for the land has been inquired into detail, and Land and Claims Commission Bhubaneswar has assessed and prepared the compensation rule of village Gopalpur, which is subsequently approved by the Honorable Supreme Court of India, and in the said approved compensation rule of villager Gopalpur, FRA compensation in respect of the petitioners are not awarded, nor in any civil cases the petitioners have been awarded FRA compensation. for the FRA Pata. And therefore, the petitioners have been advised to approach the appropriate court for their legitimate claim. It is the contention of the learned counsel for the petitioners that when the names of the petitioners were there in the list under Annexure 3 and similarly situated persons whose names find place in the list have got the compensation. There was no earthly reason not to award compensation for in respect of the petitioners. And the claims of the petitioners have been illegally torn down by the opposite party, number 2. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accept notice on behalf of opposite parties numbers 3, 4, 5, and 6, right?
There is 3, 5, and 6. 4 is yes, 3, 4, 5. Yes,
3, 4, 5, 6.
yes.
Extra copies of the writ petition be served on the land council for the state. Is there any panel counsel for Mahanadi Coalfield or notice has to go? Panel counsel are there. Who is there?
So Mahanti, the Sambit Mahanti was also.
No.
And there are several councils.
Let notice go, they may engage somebody.
By registered post, my lord.
Okay,
I'll take.
requisites for issuance of notice on opposite parties number 1 and 2. By speed post, we are making it.
By speed post, by speed.
Proof of delivery. We filed within a week, Mr. Das.
My lord, within a week.
Within a week. List this matter, put up a date after 4 weeks. The counter affidavit, if any, be filed in the meantime.
I pray, my lord, sir, also fix a date, my lord. It is difficult to get.
You can see it in the evening hours, Mr. Das, so that the correct date you will get. It will be after 4 weeks, obviously.
My lord, oblige.
Item 3.
This case, man, yesterday I filed a short notes. Also, of the copy to my little brother. It has not been entangled with the files. Let it come next week, man.
What short note?
The short notes, even it is covered under the decision of this honorable court in Narottam Rathor case. So I have prepared a short notes. How it is covered?
You have filed it.
I have already filed.
Today?
Yesterday.
Yesterday? How come? Yesterday filed my
Online.
Online. And you have served a copy on the land council for this case.
Right.
The land council for the petitioner submitted that yesterday he has filed a written note of submission.
Yes.
Indicating as to how the petitioner is entitled to get the benefit as prayed for in the petition, and copy of the written note of submission has also been handed over to the land council for the state. He further prays for adjournment of this matter to next week.
Yes, right.
List this matter in the week commencing from 6th January 2025. Yes?
On 8.
8.
8.
All right, on 8th January 20.
Item 4.
Same matter.
Oh, same matter. This is to come along with item number 2, right?
Item 6.
Lots of very pleasure. I have a glance order 12 11 2024 and 212 order. Lots of act the
12 11 2024.
My
Which is order.
the last two. Since the no opportunity is given to the petitioner while considering the appeal of the
Just Are you having that order dated 12/11/2024?
Yes.
My lord, my lord directed us to obtain instruction.
What
We seek instruction from the department, but this it has gone to different place because who are the main contestant opposite party in the learned tribunal, he has not implemented in the writ petition, the electoral engineer, to whom we will obtain instruction, and he is the main contestant party. Ignoring this particular contestant opposite party, others are implemented as a party. Let's see the cause title of the tribunal, my lord.
For divisional electrical engineer.
Yes, he is not made a party in the writ petition. The OP number 4 of that before the tribunal. Respondent number 4 of the tribunal, man.
Which is the order you are pointing out, Mr. Padi?
This may came to the page 40, annexure 7.
Annexure 7.
Yes. The respondent number 4, senior
divisional electrical engineer.
My lord, the 4 and 3 are the main contesting party according to him. He has made a party in tribunal, but he didn't made party in the writ petition.
Is it so, Mr. Counsel? That your main
They made a divisional electrical.
your main grievance is against respondent number 3 and 4.
Yes.
As per the impugned judgment which has been passed by the Central Administrative Tribunal, and you have not made those two as opposite party in this writ petition. Why don't you amend the writ petition?
Because divisional electrical engineer, I will implement my.
He said that both 3 and 4 are the main senior divisional electrical engineer, so also the divisional electrical engineer. They are the necessary parties, and you have not included them in the writ petition. So you have to file an interim application for
amending.
During course of argument, Mr. Padi, learning Deputy Solicitor General, along with so and so, submits that on perusal of the impugned order under annexure 7, which is the of the Central Administrative Tribunal Cutters Bench in way number so and so, dated so and so, it would appear that the respondent number 3, senior divisional electrical manager engineer, East Coast Railways, Khurda Road Division, and respondent number 4, divisional electrical engineer, so and so, are the main contesting parties, and they have not been arrayed as opposite parties in the petition. Land counsel for the petitioner seeks some time to file an interim application for amendment for inserting the names of these two respondents, that is respondent number 3 and 4 as per the impugned judgment as opposite parties. And for that, how much time?
Newly they employed OP number 3 is a party, he didn't have a rule.
For
the new party has added, even though he is not a party for the tribunal.
And so this matter will be commencing from 20th of January 2025. Copy of the interim application this on Mr. Padi in advance. All right.
Okay.
Item 7.
Worship. On last occasion, Worship, government has taken instruction, my lord.
My lord, it seeks time to file counter in this case. 2 weeks time may be given in the middle of filing counter.
Rest time submit enhancement comparison.
Mr. Pari, on 22/10/2024, when the matter was taken off, you made a submission that you have received the copy of the writ petition and sought for instruction from the opposite parties, which yet to be received. Therefore, you sought for 2 weeks time. So that instruction you have not yet received. for filing your counter affidavit.
We will file the counter, my lord. We will file the counter. Let me give some time. 6 per 10 days time to file counter.
No, on 22/10/2024, when the matter was taken off, we have already granted you almost 2 months time.
Yes, my lord. Last chance may be given. Within 10 days, we will file it.
All right.
Already received the instruction.
P.K. Padi, Learned Deputy Solicitor General, submits that he has already received the instruction as per the order dated 2020 from the opposite party, and he requires 10 days time for preparation of the counter affidavit. Put up this matter in the week commencing from 20th of January 2025. Counter affidavit be filed in the meantime, serving a copy on the London Council for the petitioner. Yes.
Oh, please.
Item 9.
As per the last order, they have to issue race notice.
2 weeks time, my lord. Another difficulty also that was communicated to me by the Tahsildar that he doesn't have the present address of the petitioner.
No. Forbidden submitted that the petitioner has not received any notice from the Tahsildar Bhubaneswar to remain present on the spot and so on. So however, further submitted that if another notice is issued giving sufficient time to the petitioner will definitely remain present at the spot along with the documents and cooperate with the RI to locate the exact location of the suit land. Additional government article submitted that threat notice shall be issued to the petitioner fixing another day. What happened?
Well, the address that is there in the reports is not there at that time. The fresh address may kindly be communicated.
Address for the petitioner.
Receive if there is a I'll receive another notice. But so the current address is the confirmed of them better.
No, Mr. Rostov, this is the correct address, no?
Yes, my lord. Even if the notice can be given to me, I will communicate.
Just give me intimate date when the petitioner will remain present.
My lord.
Can you give that date today so that you can mention it?
My lord. I'll give that.
We are leaving blank.
My lord.
All right, telephone. The
That is the sound box.
the Learned Additional Comment Advocate submits that since some difficulty is being faced by the opposite party, who is that opposite party? The Tahsildar, Bhubaneswar, has he arrayed as opposite party number 3 in serving a notice on the petitioner. Therefore, the order dated 12/11/2024 could not be complied with. Mr. Ross Land Council appearing for the petitioner submitted that if the Land Additional Government Advocate gives a date to him, it will be communicated by him to the petitioner so that the petitioner will remain present with the documents at the spot as per the order dated 12/11/2024. The Land Additional Government Advocate submits that the petitioner, let the petitioner remain present at the spot along with the documents on task for the data to cooperate with the RI to locate the exact location of the suit land. So, let the Land Council for the petitioner communicate this order to the petitioner. Put of this matter. The date will be according to the date provided. It is date for a date, right? Okay.
Item 10.
Mr. Rao, the last order was passed on 6/11/2024.
Yes.
Right?
Yes.
So
State government was directed to take instructions.
Are you having that order copy with you that if you pass, or please come to the Mr. Naik, please help Mr. Rao. That order dated 6/11/2020. Yes, please come to paragraph number 3. Yeah.
Yes, this petition has been filed by the petitioners with a prayer to vast notification issued under Annex 2, under Annex 4.1, under Section 4.1 of the Right to Fair Compensation and Transparency of Land Acquisition Act, and quash the entire proceeding arising therein. That should be whole land.
No, the next paragraph is relevant, please.
In the meantime, more than 17 years have passed, and particular land was required to be acquired for the purpose, that's for the establishment of the industries at the expenses of the government in the village Kalagada. P.S. Katik Sadar Katik led this land council for the state after instructions about the status of the land.
Well, the land, my lords, has already been transferred to IDCO, which was the requisitioning authority in the first place. And the ROR has also been corrected in their name. So, for what exact purpose the land is being utilized or it is lying vacant at this point of time, IDCO, my lords, will be best able to answer.
IDCO is not, obviously, it's not a party here. IDCO.
My lords, party OP 6, my
OP number 6 is there. Opposite part number 6.
Was have you received any
My lords,
in writing
that the land has been transferred to IDCO and ROR has been corrected in it.
So that we can please pass the order so that we can pass it.
Right.
Mr. Rao, that means you have not received any compensation. Keep a copy for your file or records and hand over so that you can hear us.
Then I'll
just pass it on so that we are mentioning and then we are dictating the order. Then you can give a copy also to Mr. Rao so that you. As per order dated 6/11, are Mr. S.S. Rao and senior advocate for the petitioner and Nayak and additional government advocate for the state of Orissa as per order dated 6/11/2024.
The second subparagraph from the top, I have marked it to the pen.
This possession and the land council for the state has produced the written instruction received from
the land acquisition officer Cuttack.
From the land acquisition officer from collector Cuttack dated is 25/11/2024, right?
Right.
Wherein it is mentioned that possession of the acquired land was handed over to the requisition authority and this is the line, the rent abatement statement was communicated to Tahsildar Barang.
There are more than 200 petitioners, my lord, in this case. So it's a huge extent.
Communicated to the Tahsildar Barang. Subsequently, ROR has been corrected in favor of the requisition authority. What further you want to incorporate in the order? So
now the status of the land and what purpose it is being used for the further question that was posed, it will best answer that question. It has gone to the land bank of it.
Where have you stated that it has been gone to ITCO?
ITCO was the requisitioning authority.
Acha, the requisitioning authority. Acha. Requisitioning authority for that is for ITCO, है ना? When counsel for the petitioners, that's in advocate appearing for the petitioner submitted that the petitioners have not received any compensation. That is your submission, Mr. Rao?
Possession was also not taken, but possession is still in with us. Physical possession is still with us. Mr. And physical possession has not yet been taken.
So neither the possession nor the compensation.
Neither the possession has been taken nor any compensation on either thing. To focus on the question of admission, indicating therein that the matter shall be disclosed at the stage of admission. You'll appear for which opposite parties? Nayak, you see that your file one. Nayak accept notice for opposite parties number
1 to 5.
1 to 5. Extra copies of the requisition be served on the land council for this hearing. And this Odisha Industrial Input Notice 0 and Tata Power Company Notice. Union India तो कि आपको देवे extra copy देवे. Central Pollution Control Board এটা দিব সেটিকে.
CPCB and OSPCB.
Odisha State Pollution Control Board মধ্যে দিব না. এটা লিখো. 1 to 5 লিখলো না. So far as opposite party number 8, Mr. Pari. Mr. Pari.
Yes, we are appearing for.
Mr. Pari, are you appearing also for Central Pollution Control Board?
My lord.
Yes, yes, yes.
Okay.
So 8 and 9.
So 8 and 9
Yes.
you are accepting notice for opposite party number 8 and 9. Mr. Pari accept notice, extra copy is reserved for 6, 7 and 10. Requisites for issuance of notice by speed post with relevant shall be filed.
Mr. Bhukta is appearing with.
Yes, we will mention.
Mr. Bhukta is appearing with.
Central Government Council, Mr. Bhukta is appearing along with one. So the list they do. Deputy Solicitor who belongs So you file the requisites for these opposite parties.
Yes.
6, 7 and 10. Right? This matter. 4 is for the yes. Take out a copy to given to instruction, the rating instruction is taken on record.
Requisites within 1 week.
Yes,
Requisites within 1 week.
1 week itself.
Item 11.
But item 11 and is preferred time.
The last order which has been passed.
File some documents first into the order.
Paragraph mention করছে কথাগুলো কোন প্যারাগ্রাফ মেনশন হয়েছে আমি এটা লিখছি that we have lodged
You have not filed that affidavit, madam.
and construction করছে construction কোড লিখেছি
Madam, an order was passed on 6/11/2024.
My
And
lord.
on that day, you took time to file an affidavit, which is to be filed annexing some perhaps documents.
My lord.
That as per the order dated 21/10/2024. So have you file that affidavit, or you are yet to prepare it and file it?
My lord, prepare for affidavit for some time, my lord.
Right. When counsel appearing for the petitioner submits that some further time is required to file the affidavit in terms of the order dated 6/11/2024. What time you require?
My lord, 1 week time.
20th of January 2020. All right. It will come on 20th January 2025.
My lord, oblige, my lord.
Item 12.
The item 12 on behalf of Ms. Mahapatra, kindly pass it over.
Item 13.
My lord, it is the petitioner's limited grievance, my lord, to giving a direction to the claim commissioner, honorable claim commissioner, Mahanadi Coalfields, to conclude the adjudication of Miss case number 58 of 2023 within a stipulated time. My lord, that is a matter relating to grant of compensation in favor of the petitioners, being the land
What
outskirts.
is that position there? So there was something, the judgment was reserved before the Honorable Supreme Court relating to the extension of the term of the claim commission. That order we have reflected also. That has not been extended after 31st August 2020.
And determine the position.
Because he wants a particular case to be disposed of by the claims commission, but now it is not functioning after 31st August 2020. So we are just granting adjournment.
I'll find it.
So have you got any idea whether that judgment which has been reserved by the Honorable Supreme Court, whether it has been pronounced or?
My lord, I'll take instruction, my lord.
Right. The learned counsel for the petitioner seeks some more time to obtain instruction in terms of the order dated 22/10/2020. Put up this matter on such and such date. Here.
Item 14.
Item 14, I could not file the certified copy of our past in RFA. I only pray, I may be permitted to without the liberty to file a press writ petition including the certified copy of the order.
Please file it.
I'm ready with the
Learned counsel for the petitioner files a memo for withdrawal of the petition, seeking liberty to file a better one annexing the order of the RFA number 19 of 2020, pending in the court of law and procedures on Rajsula. The memo is taken on record and the petition is disposed of as withdrawn, giving liberty.
Item 15.
Item 15, my lord, earlier it was allotted to Ms. Jyotsna Sahu, but subsequently, since she has been appointed as a state government counsel, she has to transfer the brief, my lord. May I pray 1 week after? Learned DAJ also is there.
No, it's all right. So you are to receive the brief from him.
My lord.
The mention is made on behalf of the Queen of India that for further adjournment. We are not recording any reasons, but we are just adjourning this matter.
Madam, oblige me.
Put up this matter. in the, let it be on 20th of January
My lord, my lord.
20th of January, along with Deputy Solicitor General, name of Land Council.
Pardon, annexure 14. Item number 14, certificate copy of judgment on annexure may be returned.
Which one? Item number
14. Certificate copy of judgment under
Yes, sir.
annexure 3 may be returned.
Certified copy of judgment under Annexure 3. The Land Council will have a figure memo. Land Council for the petitioner files submits that the certified copy of the judgment dated 15/2/2024 passed in CS number 38 of 2019 may be returned to him so that it can be refiled along with the in the press rate petition, which is be filed by the petitioner. Let the annexure 3 be returned, certified copy be returned to the Land Council for the petitioner on being substituted with the Xerox copy. Yes.
Item 16.
When I pay for 1 week after marriage.
You have already taken 2 adjournments.
Yes, my lord. This prayer is for a direction to the claim commission, my lord. So the matter is subjugated
The
before the
Land
honorable.
Council for the petitioner seeks for an adjournment of February of today.
Item 17.
Item 17 and 18 on behalf of Mr. Mishra, I pray for a 2 weeks time. There's some personal difficulty. 17 and 18.
Earlier also you took adjournment.
There's some personal difficulty, so he requested me to.
Right, a mention is made on behalf of Mr. Yushi Misra, advocate, for adjournment as Misra has some personal difficulty. Is this matter? Adjourn for 20th of January 2025. Alright. Yeah. Okay.
Item 19.
I will write password this one.
Yeah.
Item 19, you will see password.
Passport.
Item 20.
In this case, my limited prayer is that my representation annexure 2 is pending before the OP number 2 collector Kotak Miller. That may be disposed of within stipulated period.
This was filed on 27/6/2024.
Madam.
You have not received any communication from the
No,
concerned
no, not yet.
Item 21.
May I audible, my lord?
Yes, yes.
Yes. In this case, it was entrusted to Ms. Babita, so he joined the state. Let me give me 1 week time. In the meanwhile,
No,
we will.
Mr. Pari, the interim application has been filed to condone IN number 14022 of 2024.
Yes.
This is at flag A.
My lord.
And the prayer is that to condone the delay of 286 days in filing the writ petition. So,
Generally, in the
we
writ petition,
said
it's
that
not
out
required to
of
file, but wrongly it was filed, my lord.
we passed an order to place a office note as to why it has been mentioned in that petition that who has shown that it is 286 days delay.
Yes.
The stamp reporter has stated that there is no
It's
such
not a,
delay.
it is a writ petition. It is not an appeal to count the delays. Yes.
So we can dispose of this interim application. which
Yes,
has
my lord.
been filed,
Obliged, my
right?
lord. Yes. Yes.
And Lekhondo, IN number 14022 of 2024. This is an application under Section 5 of the Limitation Act for condonation of delay of 286 days in filing the writ petition. As per the order dated 28/10/2024, the stamp reporter has submitted the report that since there is no provision to point out delay in a writ jurisdiction, the um, same has not been done, even though the petitioner has filed an application for condonation of delay. Stop. In view of such report, the Land Deputy Solicitor General doesn't want to press the interim application. Accordingly, the interim application is disposed of as not pressed. That is IN number 1402 of 2024. Now, what further you want, Mr. Pari?
But let's me give 10 days time, then we will continue the file because file is not with me. The concerned council returned the file to us.
Right, right. The Mr. Pari seeks for an adjournment put up this matter on such answer. The main restriction that is here.
Yes, along with Mr. Maharana will appear. Let's me reply.
You must have given that list, Mr. Pari.
Yes, yes, we have given the list. Obliged. Obliged, man.
Item 22.
So Guru, kindly with glance to the last order, my lord.
19/11/24.
Yes, my lord.
Please place that order. Mr. Naik, please. 19/11/24.
So the writ petition has been filed by the petitioner, which was seeking a direction to the ADM Royal Collector, the opinion number 2 to submit the appeal memo along with all the relevant documents to the Secretary Department of Revenue and Disaster Management, Government of Odisha for disposal of the appeal. And the council for the petition submitted that the petitioner prefer an appeal under Rule 9 of the Odisha Government Land Settlement Amendment Bill 87 before the Secretary Revenue Government of Odisha at Bhubaneswar. He received the intimation from the government by letter dated such and such that he has to file an appeal petition with required court fee before the OP number 2, who in turn will all relevant document and in view of the matter shall forward to the Revenue and Disaster Management Department for hearing and decision, and accordingly the original appeal petition was written. It is further concern of the Land Council for the petitioner that in pursuance of such letter, the petitioner prefer the appeal before the OP number 2 by annexure 4, and the OP number 2 held that the farm lease of the petition is already enjoying the possession of the land earlier. It claimed for further allotment of the land appears to be not genuine and therefore deserves no further consideration, and accordingly the original application was rejected. It is further contention of the Land Council for the petition that when the when by annexure 5, the government has asked the petitioner to prefer the appeal before the OP number 2 who has to forward to the Revenue and Disaster Management Department for hearing and decision with all relevant documents and his views. It was not proper for on the part of the OP number 2 to reject such application without forwarding to the concerned authority. After arguing sometime, I am counsel for just 6 and adjournment till next week. Here is the rule, my lord. This is a rule specific for the allotment of government land in the civil township of Rourkela.
But the person is already having a land, leasehold land, can apply subsequently. That is the condition probably.
No, my lord. There's no
One can have several
No, it is a farm.
Whatever may be the nature
Farm has applied for extension of his industry. He has applied for extension of to extend his industry. Has applied for further land.
That was rejected under Annex 3.
No, he cannot be. Well, under Rule 9, it has to send to the government.
Yes,
which rule?
Rule 9.
Rule 9.
The ADM will
Forward
it
it,
to the
forward it.
government, but ADM himself
Rule himself.
Rule 9.
Rule 9.
Rule 9
of that rules for allotment of government lands in civil township of Rourkela.
Odisha government lands.
Page 58. Page 58.
Yes, yes, that is the
page 58.
Page 58.
That is specific rule for that allotment.
Allotment.
So he rejected it on his own.
His own.
Page number rule ta kate kahila?
9 page 62.
Please read it out then, Dharishji.
An appeal against the order of the committee, if processed with 30 days from the date of publication of the list of the allottees under class 7, shall lie to the government in revenue department. The petition for appeal shall bear the court fee stamp worth of rupees 300 or as may be notified by government from time to time and state the ground the appeal clearly and shall be filed before the additional district magistrate. On receipt of petition of appeal, the additional district magistrate shall acknowledge it within a week of the expiry of the appeal period, forwarded it along with all relevant papers to the Secretary Government in Revenue Department, giving his comment if any. The orders of government on the petition of appeal shall be final and ordinarily be communicated to the ADM within 4 months from the date of receipt of the appeal petition. On receipt of the order from the government, the ADM shall intimate the decision of the government to the applicant and whereas necessary issue orders, sanction, lease, which shall be deemed to have been passed on under subclause 1 of the clause 8 of for all purpose.
So who has disposed of your appeal?
ADM.
Disposed of that order, my lord. But the committee, chairman, land allotment committee, rejected the application of the petitioner on 30/11/2000.
No, we are on an appeal.
Yes, my lord.
If the appeal provision,
the appeal has to be filed within 30 days from the date of passing of that
it's all right. The appeal has not been dismissed on the ground of limitation. The appeal has been entertained on merit, but the order has been
not
passed.
a competent authority.
When is that order? It's so.
That is at Annex 3, running page 41.
No, that is ordered by this court.
That is ordered by this court.
So, Annex 41.
41.
41.
18/4/2024, my lord. Annex of 4.
Annex 4.
Annex 4.
483. Annex 83 lekha hai.
Office of the Additional District
Magistrate Rourkela.
The order is dated 18/4/2020.
Yes, my lord.
This you are challenging in this writ petition.
Yes, my lord. Because he has no authority under the Rule 9, he has to send it to the government.
No, the land allotment committee rejected your application on which
30/11/2000.
2000.
Thereafter, we have filed a writ petition, and this honorable court directed us to file the appeal. Accordingly, we have filed the
allowing the limitation petition.
Yes, my lord. This honorable court.
That is Annex 41, page 41.
Yes, my lord.
WPC number 25077 of 2020.
Yes.
No, this is the second date. Before that, my lord, I have quoted it.
But the order was passed in pursuance to order dated 7/2/2024. passed in doubt case number 25077.
This was the order passed by this honorable court, my lord. In the earlier writ 4604 of 2009, we have been asked to file an appeal.
No, in that order which you are showing us, that is annexure 3,
My lord,
that is order dated 7/2/2024.
24.
In the paragraph number 4, it is mentioned that Mr. So upon instruction informs this court that as a matter of fact,
Appeal was registered
in July 23. But the petitioner has filed
the requisite fee for filing the appeal in August 23.
Yeah.
Ergo, this court appeal for petition shall be disposed of within a period of 5 months.
Okay. That appeal has been disposed of
by ADM.
by the ADM as per order dated 18/4/2020.
There is confusion actually. Actually, appeal টা registered হবো before the government my lord. কিন্তু ये order টা pass ହେଇଛି ADM করতে পারে।
କିନ୍ତୁ ଆପଣ ରେଫରେନ୍ସ ଟା ଦେଖନ୍ତୁ ସେ ଯୋଉ WPC ନମ୍ବରଟା ଯୋଉ ପଡିଛି ସେ ନମ୍ବରଟା ସମାନ ନା।
ହଁ ନମ୍ବର ସମାନ।
ତେଣୁ ଏଇ ଅର୍ଡର ବଳରେ ଯଦି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି ଏଇଟା ଜଣା ପଡିବ ଯେ ଅପିଲଟା ହିଁ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି by virtue of this order under annexure which the ADM lacks power in view of this
Rule 9
5 na
Rule 9, yes.
But then where is the order of the land allotment committee?
That is not.
That is not.
Where is that?
That is not.
No. That is the order of the land allotment committee. It appears. The order passed by the ADM being the chairman of the land allotment committee. Otherwise, where is your
This
order?
is the chairman of that committee.
Where is that order?
I have not annexed it, my lord.
No, is there any order to that effect?
Yes, my lord. Because against that order, we have initially we have filed the WPC number 4604 of 2009.
No, that order doesn't refer to any order. The order of this court doesn't refer to any order.
My lord.
Where is that?
It is only mentioned in the order of this court that an appeal has been filed and it has been registered also. That has been stated. And but you filed the requisite fee in August 2023.
Yes, my lord.
Right.
Right.
And then this court directed that this appeal is to be disposed of within a period of 5 months.
5 months.
And of course, this particular writ number is mentioned in the top of that order under the heading of subject.
Yes, my lord.
Whereas it is clearly mentioned in that order that the land was the allotment of land application for allotment of land was discussed in the land allotment committee held on 8/10/2023 and was rejected on the ground under as per rule 3G2 OGLS. Allotment of land should not be made in favor of any individual or farm who has already possessed land within Rourkela Civil Township or Steel Township area for the purpose applied for. In the instant case, Mr. Messrs. Mahavir Printers has already been allotted
plot number 80 for 0.82 decibel of land by ITCO in the industrial area.
Since your farm is already enjoying possession of land.
But this, if he was a part of that committee,
he cannot
he could not have decided the appeal, right? That is the provision why it has been
Section 9
stated
is
that he has to be submitted.
No, he has, in fact, the ADM has disposed of the appeal as it appears. Though the land allotment committee earlier has disposed of it on 8 and
not mentioned. In the
appeal number is not mentioned.
The order it is stated that the appeal already registered since July 2023. But in the impugned order, the appeal number is not mentioned.
That is, but it is appears that this was taken note of. This writ petition order was taken note of by the learned ADM. So, if he was a party to that initial order, he cannot be the appellate authority also, right? That is the exactly reason why.
In any case, what prevented you to move in appeal?
No, initially.
No. Have you ever moved in appeal?
Yes, that
Where
was
is that?
returned to us.
Where is that?
That is annexure, last annexure, my lord.
Annexure 4.
Yes, that was returned to us to file before the ADM.
No,
No.
It will appeal will be filed before the ADM
And he
ADM
will
return.
yes.
Yes. No.
So you were direct advised to file the appeal before the
The
ADM.
last
Who
paragraph.
will, along with documents, will.
In the last paragraph, my lord, that initial last paragraph. Hence, your original appeal petition is written here.
Here.
That is why, for the purpose to be sent.
Can I have a glance to annexure 1, man?
Yes.
The appeal was filed before the Secretary Revenue Government of Orissa.
Right.
Directly it was filed before the.
Yes.
Therefore, the Secretary returned the file appeal memo with advice to file the appeal before the ADM, who will do the needful thereafter.
It was the rule 9.
Where is that order passed?
Annexure.
Last annexure, man.
4.
Annexure 4.
Page 43.
No, you
return
545.
No, annexure 2 return.
Annexure 5, page 45.
They said return appeal petition before this learned court for consideration and necessary action.
Page 45, Miller. Page 45. Annexure 5. Page number.
It actually confused annexure to effort support. Otherwise, this is the direction issued by the appellate authority.
Yes.
To file it before the ADM.
ADM, he will send it with all the.
So instead of sending it to the government, the
Yes.
ADM has decided it.
Himself.
No.
नहीं तापर एडीएम पर अपील फाइल लेना
appeal
हाई कोर्ट का ऑर्डर टा नहीं कि एडीएम पर
ना we have filed it.
ना कहीं से डॉक्यूमेंट
से डॉक्यूमेंट अच्छी
ताले एडीएम केमती लखले जे लैंड अलॉटमेंट कमिटी मीटिंग हला बोली कि 23 रे
next to.
No, if the order of the land allotment committee is under appeal, then how in the impugned order the ADM has mentioned that the LSC meeting held on 8/10/2023? The LSC meeting ought to have been prior to 2022.
22.
Where is that order?
Price.
Where is that order from your side?
We have not been supplied with. We have only supplied with this rejection order.
No. That means this is the order of the LSC.
No, my lord.
Either way.
No.
No, basing on which you have gone on appeal in annexure 1. Where is that order?
Basing on the order, my lord, we have already submitted to the.
Where is that?
We have. I have not annexed
come
it.
with that order.
I have not annexed it.
Now you kindly show that order. That will remove all the confusion.
That is why, my lord, this is the order passed by this honorable court.
No, Mr.
To direct us to file the appeal.
Mr. Guru, kindly, if it is there, it is there. If you could file an appeal on the basis of the rejection order of the land allotment committee, you preferred the appeal?
No, my lord.
No, you have preferred the appeal.
No. Initially, we have filed the writ petition.
Before going to the authority?
Yes, my lord.
How could it be?
4604 of 2009.
How could it be? Without an order, without anything?
No, with an order. With an order, we have filed it. The WPC number 4604 of 2009.
Mr. Guru, number 1. You made an application before the land allotment committee.
Yes, my lord.
For allotment of a leasehold land.
Yes, my lord.
The land allotment committee, having considered your application, rejected it.
Yes, my lord.
Basing on that, you preferred an appeal.
No.
Then
we have prefer a writ petition.
Basing on what?
That rejection order. This honorable court directed us to go.
All right. If this court directed you to prefer an appeal,
yes.
When you filed the appeal, where is the order annexed to it of the land allotment committee? How could you know that your application has been rejected by the authority? Where is that order?
Yes, I will file that order.
You kindly file that order. That will remove all the. In that case, we can give it.
Annexure 1, page number 39.
Page number 30.
Prayer.
Prayer.
In the appeal, the petitioner challenged the rejection order dated 30/11/2000 and 4/7/2001. That is the order passed by the land allotment committee. That application was filed directly before the government. That's why government returned. Thereafter, again the land allotment committee rejected the application of the petitioner on 8/10/2023. Challenging the
returned appeal is filed. So, Mr. Nayak, he should not have decided this case.
That is true.
Listen, the this petition has been filed by the petitioner, Hitawas Misra, seeking for a direction to the ADM Raukala opposite party number 2 to submit the appeal memo along with all relevant documents to Secretary, Department of Revenue and Disaster Management, Government of Odisha for disposal of the appeal. It is the contention of the Land Council for the petitioner that the petitioner is the proprietor of Messrs. Mahavir Printers located at AY8 Commercial Estate, Raukela, and he publishes daily newspaper in the name of Utkal Mail in the and installed a printing press in the name of Mahavir Printers for publication of such daily newspaper. The petitioner is registered under the provision of Press Registration and Books Act 1987, 1867. 83. No. The petitioner has also registered under the Registrar of Newspaper of India. And the petitioner was managing the press at AYA-8 Commercial Estate, Rautala, and he found the space to be inadequate to accommodate the requirement of the newspapers. That is, one is that Utkal Mail and the other is Kurukshetra. And to install sophisticated machineries for better publication and for the expansion purposes. Since more land and things became necessary, he submitted to the respondent number 3, that is Land Allotment Committee, Raukela, for allotting an area of Ekosum 560 decimal of land relating to pertaining to the plot number 81P under Khata number 3 of Raukela Town, unit number 39 of Raukela 4.
Respondent number 2.
Respondent number 2. अच्छा, respondent number 2 है कि अन्ना ताकि ये था कौन? Respondent
Land Allotment Committee. Respondent number 2.
Land Allotment.
3 के ना है.
It's 3 के ना है. जरा भूले है ना. Alright. sounds taken that you have, your application was rejected, you said?
No, initially it was recommended for allotment by the Tahsildar. That was paragraph number 9.
Mentioned, this is totally confusing.
Confusing.
This is respondent number 3, 5, what a phone to listening.
Well, I may be permitted to withdraw and file a better application. Permitted to withdraw and file a better
Land
application.
counsel for the petitioner, 6 permission to withdraw the writ petition. Is filed a better one. This petition is disposed of or withdrawn. Yes, giving the verdict.
Item 23.
Today I have received the otherwise comment from mail, my lord.
The land counsel for the petitioner is present, land counsel for the state submits that he has received the Parawai's comment today, and he will file the counter affidavit. 2 weeks time may be granted. 2 weeks of time, put up this matter in the commencing from 20th of January 2025. Counter affidavit copy we served on the land counsel for the petitioner in the meantime. Yes.
Item 24.
See the last order dated 10/12/2024.
But subject to losses consideration.
Just come to that order.
Yes, my lord. Order dated 10/12/2024.
Please,
Yes, sir.
place that on.
Lord Counsel for the opposite party number 3 to 5 has filed an affidavit in court today, which is
Will be appealing for 3 to 5.
My lord, yes,
All right.
which is taken on record. Let a copy of the affidavit be served on the Lord Counsel for the petitioner, sole Sovereign Counsel for the state. The petitioner Dhruva Kumar has filed this writ petition seeking for a direction to the opposite party number 3 and 4 to release compensation amount in terms of the order dated 13/1/2022 on Annexure 1, order dated 16/1/2023 on Annexure 6, and letters dated 4/6/2024 and 28/2024, and the proceeding dated 27/2024 under Annexure 7 series within a stipulated period, and with a further direction to the opposite party number 1 and 2 to pay the compensation to the petitioner as per order under Annexure 6 and 7 series with interest and recover the same from opposite party number 3 and 4. It appears that the opposite party number 5 earlier approached this honorable court in WPC number 27355 of 2022, and this court by order dated 22/11/2022 disposed of the same, directing the opposite party number 4, Department of Energy, Government of Odisha, to consider the representation filed by the petitioners in the said case and pass appropriate order in accordance with law within a period of 4 weeks from the date of production of certified copy of this order. In pursuance to the order passed by this court, it appears that the Government of Odisha Energy Department, by order dated 16/1/2023, found that there is no illegality or impropriety in the order passed by the Collector Balangir, OP number 2, and accordingly directed the CEO TPWDL to take steps to purchase or acquire the land in the name of the Department of Energy, Government of Odisha from rightful or recorded owner of the land with necessary approval from all concerned on payment of compensation as per provisions laid out in the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act 2013, and the payment towards such compensation shall be governed under the respective vesting order of the commission, that is OERC. It is further appears that a committee was formed which is called District Compensation Advisory Committee, in which the Additional District Magistrate Balangir, the Sub Collector Patnagar, the DFO Balangir, the Tahsildar Khaprakol, the Superintending Engineer TPWDL Electrical Circle Balangir, the Sub-Register Patnagar, and the Land Acquisition Officer Balangir were the members of the committee, and accordingly the market value of the land was determined. In pursuance to such decision taken in the meeting, the Land Acquisition Officer Collector Balangir by letter dated 29/8/2024, which is addressed to the Superintending Engineer TPWDL Electrical Circle Balangir, requested to deposit 2% of the contingent amount worth 2,09,462 in favor of the land acquisition officer collector at Balangi at the earliest through account pay check. It is the contention of the land council for the petitioner that such amount has not yet been deposited, for which no progress could be made. After hearing the land council for the respective parties, we direct that opposite party number 4 and 5 to make necessary deposit within a week. List this matter on 23/12/2024.
Yes.
Yes. My instruction is for this order also is consideration that the management has in fact filed a SLP for the annual apex court on 23/12/2024. It is in the diary stage also kind of glance. I have given this
Against this order that to deposit the 2% of that.
my lord, entire issue because the TPW has only the user's right over the property. It is the land of the government. And this direction that energy department that is contrary to their own notification. They have made a notification on 23/12 we have filed. I mean,
Yes.
because of the intervening winter vacation.
No, it's all right. What you are challenging before the Honorable Supreme Court?
That order, this order and the enter the proceeding orders. My instruction is that. With to set at rest the issue because the TPW has only the license or user's right, only use. And you'll also tell you the notification that Government of Energy Department. Clause 10.
Have you got a copy of that SLP? Just to know that what is being challenged there.
That in fact they have sent in the WhatsApp. I have not printed out to Lordship.
No, you get the copy. You can take it this matter tomorrow because Mr. He can also know, Mr. Dadar, what exactly you are challenging.
Tomorrow I will supply.
If order was passed on 16/1/2023
or day after tomorrow, also the SLP is converted.
After tomorrow, you give a copy of the that SLP to the
state also.
The London Council for the opposite
Your
party.
Lordship, Monday, Lordship. Because day
after tomorrow.
Yes, Monday.
Monday.
In the meantime,
I'll give one.
The London Council for opposite party number 3 to 5 files a memo wherein it is mentioned that the licensee oblique PPWODL bracket opposite party number 3 to 5 had moved the Honorable Supreme Court on 23/12/2024 by diary number 60660/2024, and a slip has been attached in that respect. The memo is taken on record. London Council for the opposite party number 3 to 5 submits that you will supply a copy of the SLP to the London Council for the petitioner. So also file a copy for the court. And to the state, and to the state also. And matter may be listed next week. This matter on 6th January 2025, right?
Item 25.
25 Your Lordships, on the last occasion, my lords had directed to take instructions in the matter.
Just a minute. Yes.
I humbly pray for 2 weeks' time to file an additional affidavit.
Additional affidavit.
Yes, madam.
Mention is made on behalf of Mr. Bihu Prasad Das and Council for adjournment to file an additional affidavit. 2 weeks time of this matter. Let it come then on 20th of January. 20th of January 2025.
Item 27.
Made periods. Last episode also wanted to know the order passed in the earlier writ application
You have not annexed the copy of that order.
Yes, yes.
That is why we asked you to.
Yes,
file.
yes.
Have you filed it?
Lordship, and just now I'm saying.
Give a copy to also.
Yes, yes, yes.
So what is your prayer in this writ petition?
So, prayer, Lordships, petitions paid for 1/3 share of the awarded compensation amount of Lordships.
Why 1/3 share?
Because Lordships she is entitled for 1/3 share of Lordships as per the legal heir Lordships.
So who are the other?
Other are Lordships petitions husbands brothers Lordships.
No, why they have not been arrayed as opposite party in this?
You Lordships,
they have a right to also hearing. If you want 1/3 share of a property, which is also other claimants are there, then is it not necessary that you should have arrayed them as opposite parties?
Your Lordships, before the land acquisition official I approached, and there are Lordships
no, if we say something that the petitioner is entitled to 1/3 share of a compensation amount, then they may come to say that no, you are not, this petitioner is not entitled to. In fact, we are also entitled to. So that is the reason why we.
They are not objecting that, Lordships.
Who is not objecting?
How can we know that they are not objecting? On your version, can we record that they are not objecting? Profulo Swine, your father,
husband of the petition Lordship.
Your husband. Yes, so who are the other co-sharers?
Your Lordships, page 13, Your Lordships, I have submitted the legal heir, Your Lordships. One of the Ogadu Swine is the main father-in-law of the petition Lordships. He has 3 sons, Lordship.
No, this is the legal share certificate of Ogadu Swine.
Ogadu Swine.
No, your husband's name is Profulo Swine.
Profulo Swine.
My name does not find place here.
Your Lordships, he has died, Your Lordships.
So unless that comes, you come on record first, how can you expect it?
Then, Your Lordships, I will make them party.
So this particular land, as per the ROR, stands in whose name?
So it is Ogadu Swine.
See, if it stands in the name of Ogadu Swine, and according to you, that these are the persons who are the legal heirs, then how your husband came into picture and how you also came into picture?
My name is serial number 3, Manjulata Swine.
Yeah. Daughter-in-law. In that way, your name is there.
Yes, sir. And my,
but there are other persons.
Yes, also. 5 and 6 are my sons, Lordship.
So maybe your sons, they may also object that it should not be dispersed in favor of our mother. Cannot say that they are my daughters, so they will. One is married, another is unmarried. So your daughter might have also the objection. We should have included all the legal heirs of that man, Ogadhu.
Yes, Lordship. Then Lordships, I be permitted to withdraw this petition with the liberty to file a better petition.
Go to memo then. The learning counsel from the petitioner files a memo to withdraw the writ petition to file a better one, giving liberty to file a better one. Memo is taken on record, disposal, giving liberty.
Item 28.
Last division Lordship has directed to take instructions so that the awarded amount has been disbursed not as per Annexure 3 manual.
Please come to that order 2/12/2024. Have you got a copy of that order? एटी बाहर कर दिले थे बॉटम ये से पिला उड़ा दी नो अवसर है 2/12/2024 file it. Please read it out.
Matter is taken up.
No, just next. This repetition.
This petition was filed by the petitioner Sanjuala Singh with a prayer for a direction to the opposite party number 4 for disbursement of the compensation amount as per notice under Annexure 3 dated 23rd 8 2012 issued in favor of her husband. And counsel for the petition submits that the petitioner's husband has not received the compensation amount and he died on 22nd 7/21. In support of such submission, she has annexed the death certificate to the petition as per Annexure 4. And counsel for the state seeks some time to obtain instruction as to whether the compensation amount as per Annexure 3 has been disbursed in favor of the petitioner's husband or not.
Yes. In fact, that amount has not been disbursed, but report is coming. So for the judgment of the Honorable Apex Court, that allocation of the has been cancelled, but that they are not given the particular whether that plot has been allocation has been cancelled or not. That part has not been written. So
No. If you are yourself is not clear.
Yes, that's why I'm saying. They are only saying that the
No. Get it clear one whether it is acquired.
It is acquired or not. And if you say that
they are acquired and the amount has been they have not received the amount also.
So you have to pay it.
But so far the that matter has went to the Apex Court and the Apex Court has cancelled the
lease the
allocation land. But that has not mentioned that whether his
where is the order, where is the
that
details of land,
that they are not giving the Supreme Court number also.
No, number ଆପଣଙ୍କର ଆଙ୍କର ଯୋଉ ପର୍ଟିକୁଲାର ଲ୍ୟାଣ୍ଡଟା ସେଟାକୁ ଆପଣ କହୁଛନ୍ତି ଯେ ଆକ୍ୱାର ହେଇଥିଲା ଏବଂ ଆଡମିଟେଡଲି କମ୍ପେନସେସନ ଆମାଉଣ୍ଟ ପେମେଣ୍ଟ ହେଇନି ତ ସେ ଲ୍ୟାଣ୍ଡ ଆଲଟମେଣ୍ଟଟାକୁ କ୍ୟାନସେଲ କରିଦିଆଗଲା ବୋଲି ଯଦି ଆପଣ କହୁଛନ୍ତି then there should be a specific counter affidavit you are to file and along with that the judgment of the Honorable Supreme Court that is also to be ordered.
2014.
Otherwise, she is entitled to get the compensation. File your counter affidavit.
Then file that way.
As per order dated 2/12/2024, the Land Council for the state placed the letter dated 12/12/2024 of the LAOGN Collectorate Hon'Ble opposite party number so and so, wherein it is mentioned that ଲେଖା ହେଇଛି ପିଟିସନର ଫାଦର କଣ ଲେଖା ହେଇଛି ବିଭୂତି ଭୂଷଣ ସିଂ ତା ଫାଦର ନା ତା ହଜବେଣ୍ଡ ବିଭୂତି ଭୂଷଣ ସିଂ ହଉଛି ତାର ହଜବେଣ୍ଡ ଆପଣ ଲେଖିଛନ୍ତି ତା ଫାଦର
did not receive his comment, did not turn up to receive the compensation.
That the petitioner's husband Vibhuti Bhushan Singh did not turn up to receive his compensation, nor he has given any written complaint before the LA collector about his compensation for which the award amount has not been disbursed to the awardee and the compensation money is lying with LAO /G on board. Copy of the award register and 12 notice has been annexed to the said letter. However, it is mentioned that the Honorable Supreme Court by judgment dated 25/8/2014 and order dated 24/9/2014 has cancelled allocation of 204 coal blocks, and Patrapada coal block is one of them. The letter is taken on record. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of all the opposite parties. Extra copies of the writ petition be served on the Land Council for the state. Matter be placed 4 weeks after date delivery. Counter affidavit, if any, be filed in the meantime. This is the copies taken on record for them. আর ଗୋଟେ কপি ତାଙ୍କୁ କରିକି ଦେଇଦିଅନ୍ତୁ ହେଲା ବାକିଟାକୁ ରେକର୍ଡ ରଖି କାଉଣ୍ଟର ଆଫିଡେଭିଟରେ ଆପଣ ଡିଟେଲ ସେ ବିଷୟରେ ଦେବେ ହେଲା
Item 29.
The land of the petitioner was required for construction of national highway. And annexure 4, page 61 is the award proceeding under section 3G of the NHA. Fact remains the petitioner purchased the land subsequent to the notification, but the award passed in favor of the petitioner. As the same was not in consonance with the value of the land as well as the structure standing thereon, petitioner raised objection to this award. PG.
What happened then?
Then the same award was again passed. So I approve this honorable court in a writ petition. This honorable court directed to dispose of my representation. And the collector had annexure 12, page 87, 85. Rejected my claim on the ground that I have constructed the structure after 3A of the NH Act. Fact remains in the year 2017, the notice was made and declaration in the year 2018. No award passed for around 6 to 7 years. And till yet also they have not taken possession of the land. And I purchased the land in the year 2022 as because neither the NS took possession nor paid the compensation to the original. And I have constructed there.
Annexure 12.
Yes, page 87 is the ordering portion.
87.
Yes.
Please read it out that portion.
In view of above submission of both the parties and so also the finding of the case, this court observed that the petitioner had purchased the case land on 4/3/2022 had e-registered ID number and constructed structure thereon after publication of 3A notification and 3D declaration as per the provision of National Highway Act 1956. The structure over the khata number so and so were not present at the time of notification and declaration. As the petitioner is not entitled to pay any compensation in such circumstances for structure and as claimed or as per the provision of the land acquisitions. Further, the land acquisition officer is directed to ensure intimation to all officers concerned during the process of land acquisition, henceforth with freeze transaction on concerned land schedule when land acquisition is in process. This court further ascertained the sub-register of Koksara and the Tahsildar of Koksara had allowed registration, mutation, and conversion of the case land in question during the process of the land acquisition despite even Tahsildar in 2017 signature. Hence, this court directs the sub-collector of Dharamgad to issue so-called to see Debabrata 40 OS, even sub-register from Tahsildar, Koksara and the concern arise by action as deemed proper to not be initiated or lapse.
So that is against them.
Yes.
So,
Yes.
But the reason has been assigned as to why you are not entitled to.
Competent authority has passed the award. Now the collector or the executive engineer, being the arbitrator, he should decide the matter so that I can avail the forum. Now here the collector has passed this order without in a miscase. So now it is not possible on my part to challenge this order as because this is related to the award passed by the land acquisition officer.
No, Conan also wanted.
Your ship come to 3G of the NHAI.
Here.
3G. Determination of amount payable as compensation. Your ship come to clause 5, subsection 5.
5, yes.
If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government.
Yes.
Subject to the provision of this act, the provision of the Arbitration and Conciliation Act 1996 shall apply to every arbitration under this act. Now here the collector should pass the order being an arbitrator of the proceeding as per this act. He has passed this order in a miscase.
He has passed
this order as administrative officer, not as an arbitrator.
Yes,
In pursuance of the order dated 5/4/25 passed by the Honorable High Court of Orissa in connection with the double petition of such and such, this matter is taken up for hearing. And my lord, the NHI is not a party also here.
Okay, one. Opinion one. Copy to one.
One, human fingerprint for the Secretary Government of Road and Transport.
Yes.
No, why this was filed? The question is that he claimed higher compensation.
My lord.
Right? So the authority is to decide whether he is entitled to get the higher compensation or not. But he has mentioned that he is not at all entitled to get any compensation for the structure as claimed, so and so. So that is on what basis?
At the time of land acquisition, the structure has not been made. After the notification, the structure has been made.
So even though he has purchased the land, he was entitled for the compensation against the land, but not for the structure.
And here in the case,
because it has come later.
Party, so that he can say also. The NHA has not made a party.
4. I believe 4.
Executive Engineer, NH Division. NH Division, National Highway Authority.
Chief Engineer.
Chief Engineer. I will execute the Chief Engineer. The Super Engineer.
And that is, sorry, so far the NHA is concerned. NHA is not a necessary party here. Necessary party the Chief Engineer and NHA. The NHA has two authority. The Road Transport Authority has assigned this certain states of national highways to the Chief Engineer Highway under the state government, which is function under the state government. That is R&D deputy.
No, we'll see on that. So, the observation jahata dejan, this particular structure over khata number so and so was not present at the time of notification and declaration. It came subsequently. So that is why you are not entitled to get compensation for the structure.
Yes.
Right? So he has justified that how he came to such finding. So how do you say that?
Yes. Here what happened? I have purchased the land after notification also.
No, that is not denied.
My notification. Then the land was allowed to be converted to homestead land. The officer concerns, they have allowed me to, they have converted my land to homestead. Then I have constructed the land. In the year 2017, notification was made. For 6 years, they didn't take any step, even till that I'm in possession. Till that I'm in possession.
No, you purchased it in 2022.
Yes.
So where is the question of 6 years?
No, no, 2017 notification.
All right, but
I
knowing
thought,
fully
yes.
well that the land is already
No,
acquired.
that is the problem, my lord. That in the year 2017, notification was made.
Yes.
What they are saying.
Hmm.
Till date, they have neither they have taken possession nor they have paid the compensation to anybody else. Compensation also not paid as on date. And notice was issued to me as because notice was issued to me for receive a compensation award pass in my favor.
Right.
Though I am subsequent purchaser.
Right.
By the time I have constructed the building.
No, but that is not there.
And my lord,
now you have to substantiate.
My lord, there is a,
You have to substantiate that you have brought the building there.
Yes, my lord. Now how I will substantiate?
Before
the arbitrator.
Yes.
Now collector is the arbitrator. He has already passed order against
So
me
you
in
should
a
have
case.
no. It is on the basis of your claim that this court has passed a direction. You should have placed it for the collector.
Here collector is the arbitrator. So collector should pass the order as per Arbitration Act.
Sir, then you should not have agreed for the direction issued by this court. Having acceded to the direction passed by this court, you were amenable to that authority.
I approached the collector. Collector did not take any steps, so I approached this honorable court.
That is right.
Yes.
And now the court passed an order.
Now I am remediless.
Why? The court
the same collector, how he will pass a separate order in Arbitration Act?
That you should have questioned yourself when you got the direction from this court.
So I pray one thing, my lord, you also may dispose of the writ petition, granting liberty to file appropriate application with the collector, and the collector may pass independent order without influence by this order. Otherwise, this order will be heard of contempt. And if the collector again pass order against me, then I can approve this honorable court.
What was your prayer before the collector?
Yes.
In that miscase number 9 of 2020.
Yes, ma'am. Next 6.
You got a copy of that miscase?
Yes, 79 years, page 79.
No, this is a representation.
So right, this is CPAD actually collector motive नहीं आपकी.
Considering my application and make a payment by a
no, where is the copy of that miscase?
There is this is the written thing.
Ceremony.
This is ଆପଣଙ୍କର prayer କଣ ଥିଲା?
Let me obtain that.
କାରଣ ଆପଣଙ୍କର ଏଠି ଆସିଲା ଯୋଉ ହାଇକୋର୍ଟ କୁ ଆସିଥିଲେ ଆଗରୁ representation dispose of କରିବା ପାଇଁ prayer ଥିଲା. So that order has been passed by this court that you said that representation has been made before the opposite party number 2 and the same may be directed to be disposed of. So direction दिया जे dispose of କରିବା ପାଇଁ. But certainly this court finds that so far as this order particularly which is under challenge in this writ petition,
my lord,
that is passed in miscase number 9 of 2020.
Come to Annex 6, page 67.
Annexure
6, page 67.
Yes.
This is the representation given to the collector.
Representation upon miscase ro कोन आपनकर गोटे पिटिशन आपण दाखल करथिबे ना ताऊ
ए जो आर्बिट्रेटर हिसाब रे जो दबा पई
Annex 6 तक ही डायरेक्शन दिया था टू डिस्पोज ऑफ दिस Annex 6. एटा मिसकेस नंबर है
से गुडा को मिसकेस रजिस्टर करछन
आगे
ये जो आपनकर रिप्रेजेंटेशन
आगे
को लिखा है काई
order of this honorable court to dispose of Annex 6, page 84.
ଯଦି କିଛି ଜଣା ପଡୁନି ସେ ଅର୍ଡରରୁ ଯେ ଆପଣଙ୍କର ରିପ୍ରେଜେଣ୍ଟେସନ ଟାକୁ ସେ ଗୋଟେ ମିସକେସ୍ ହିସାବରେ ଟ୍ରିଟ୍
ନାଇଁ ସେ
କରୁଛନ୍ତି।
ନାହିଁ
ବୁଝିଲେ
order is silent.
ଆମେ ଆପଣ ଭାବୁଛନ୍ତି ଯେ ହୁଏତ ସେଇଟା ହେଇଥିବ କିମ୍ବା ହୁଏତ ହେଇପାରେ ଯେ ଆପଣଙ୍କର ତରଫ so when you are not having the order sheet ଯଦି order sheet ଟା ଆଣିଥାନ୍ତେ ମିସକେସ୍ ନମ୍ବର 9 of 2024 ଫାର୍ଷ୍ଟ ଅର୍ଡର sheet ଟା ହୁଏତ ଥାନ୍ତା ଯେ ଏଇ ରିପ୍ରେଜେଣ୍ଟେସନ ଟାକୁ ଟ୍ରିଟ୍ କରାଗଲା as a miscase and miscase number so and so is registered. Matter ends there. ଏଠି ଜଣା ପଡୁନି clearly.
In page 84, you have to be directed to dispose of the
representation.
Yes, annexure 6. And annexure 6 is
we are mentioning little you please clarify
Madam.
and bring that order sheet so that
Madam.
This writ petition has been filed by the petitioner to seek a stay. Inter alia, the prayer for a direction to the opposite party number 2, Collector and District Magistrate Kalahandi, to adjudicate, public send the matter for determination of award by the arbitrator appointed by the central government in accordance with section 3 bracket with G bracket with 5 of National Highways Act 1956. The Land Council for the petitioner submits that the impugned order is dated 19/7/2024, passed by the Collector and District Magistrate Kalahandi in this case number 9 of 2024, which has been annexed to this writ petition as annexure 12. He submits that earlier the petitioner filed the writ petition by WPC number 7683 of 2024 and by order dated 5/4/2024, this court has disposed of the said writ petition with a direction to the opposite party number consider and dispose of the representation filed by the petitioner filed annexure 6 to that writ petition and to pass appropriate order. When we asked the London Council for the petitioner to provide a copy of the petition in miscase number 9 of 2024, the London Council for the petitioner submitted that perhaps the representation submitted by the petitioner has been registered as miscase number 9 of 2024 by the Collector and District Magistrate Kalahandi. However, he seeks some time to produce the entire order sheet of the miscase number 9 of 2024 to substantiate such submission. List this matter in the week commencing from Quebec. We commencing from 13th of January 2025. The Land Council for the petitioner shall produce the receipt of the miscase number swan on the next day, 9 of 20.
Item 30.
Can you see the order dated 9th December 24?
Have you got a copy of that order?
Yes, please.
Please. No. You don't know. Want that you should place it. Please do that.
The Council So the state was to obtain instruction about the status of the application under annexure 1.
What is that annexure 1?
That was filed, the bank is the petitioner before your lordship. The bank had approached the Telangana District Magistrate Jagsingpur seeking appropriate order under section 14 of
Section 40.
14. That was
I'm sorry, we already sent the letter on 11/12/2024. No instruction has been received.
We are granting you one more week.
One week more. May I pray one thing, Lord? This is the letter. This is the petition of the bank, but they are not mentioning the miscase number. So that is not whether that is registered or not. Let's apply that number so that we can.
No, that was the format. That was the format.
No, section 4.
And the miscase, that
case number
miscase se bar coordinate that they have not entertained that. That is why
The office of the collectorate have not entertained this
yes,
application.
not exactly. And they subsequent.
Since when? When did you file it?
That was filed on 31st 1/22. Again, they have said that application was misplaced. So that is why on 4.
Again, it has been filed on.
That is
Again,
kindly. Don't
again, it was submitted on second.
Mr. Naik, please
Yeah.
come to that annexure 1 series. In the matter of an application under section 14 of the so and so. ହେଲା ଏଇଟାକୁ ସେ ଗୋଟେ ନମ୍ବର ମଧ୍ୟ ଦେଇଛନ୍ତି ତେଣୁ ଆପଣଙ୍କର ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବା କଥା ଯେ ଏଇ ଆପ୍ଲିକେସନ ଉପରେ କଲେକ୍ଟର କିଛି ଆକ୍ସନ ନେଇଛନ୍ତି ନା ଡିସ୍ପୋଜ ଅଫ କରିଦେଇଛନ୍ତି ନା କଣ ହେଇଛନ୍ତି ଏତିକି ଆଣିବା ଆଉ ଏତେ କଥା କଣ ଦେଖନ୍ତୁ the learning council for the state seeks one more time to obtain instruction as per the order dated 9/12/2024. Place this matter. 13 तारीख में हो?
Can I pray for 15?
2025. अच्छा 15 तारीख में 15/1/2020.
Item 31.
Just to remind that matter, just to remind my lords, the guarantor has redeemed the mortgage and they are supposed to return the document. Last date, Mr. Sahoo took instruction to file an affidavit.
Yes,
they have filed an affidavit. I have also taken instruction. If lordship see para 4 of flag 10.
What is the affidavit?
Lord, flag 10. Para 4.
Yes.
Para 4, if lordship could kindly see, that's the relevant paragraph.
Please place it, Mr. Roko.
Lord, that such being the factual circumstances of the matter.
Paragraph 4 is very important.
He is reading that.
That such being the factual circumstances of the matter, since the guarantor has paid the entire outstanding dues, and now the guarantor is demanding original title documents pertaining to loan account number so and so, by executing deed of indemnity undertaking therein, to indemnify the bank against all future claims raised by the borrower at a later point of time, as well as indemnify the bank against any legal liability of discharging such original documents to the mortgagor cum borrower. Then, upon execution of such deed of indemnity of original documents may be handed over to the guarantor for avoiding further future litigation in the event husband, that is the principal borrower cum guarantor, comes back and demands the documents.
So he will appear on the particular date, hand it over, that matter ends there.
By furnishing the letter of
That we'll just quote it.
Yes.
She will appear, tell us a date when, so that she will not face any difficulty. She's a lady, so tell. She's of Puri, na?
Yes, Puri.
Tell us a date. She will appear. Any date.
7th, 7th or 13th. Let it be 13th, so that 1 week time.
13th. All right.
One more thing. Paragraph 5 is also very important.
पूरा quote कर दो, अपन जहाँ लिखी थी
4 and 5 is.
ठीक है, लिखो. This writ petition has been filed by petitioner Omita Bhattacharya. The prayer for a direction to pass the letter dated 29/10/2024 issued by the opposite party number 2 bank with a further direction to the bank to return the original documents in respect of loan account number so on. Their portion. As per order dated 18/12/2024, Mr. S.K.Sahoo and counsel for the bank has filed an affidavit of the branch manager Union Bank of India, Puri 2, Pacheri Road branch near Town Hall, Puri, wherein in paragraph number 4, it has been mentioned as follows. Paragraph 4 and 5.
Five also be there.
4 and 5 it is mentioned as follows. Quote, paragraph 4 and 5. The learned counsel for the petitioner submits that the petitioner is ready and willing to execute the deed of indemnity as mentioned in the aforesaid paragraphs. And a date may be fixed so that the petitioner shall appear before the bank authorities and execute the document. On consensus of both the parties, date is fixed to 13th of January 2025, on which date the petitioner shall appear before the branch manager, Union Bank of India, opposite party number so and so at 10:30 a.m. And after executing the documents so and so, the documents as referred to so and so shall be handed over to her. Accordingly, the writ petition is
In respect of the loan document.
loan document. Obviously, of
Whatever, yes.
That's right.
Yes.
Grateful.
Item 32.
May I please your lordships. My lord, the petitioner in this writ application challenges the order dated 27/7/2024 passed by the learned second additional district judge Bhubaneswar under Annex 4, my lord. The fact of the case is like this, my lord, that the petitioner has availed a loan for his Xerox center, my lord, and due to non-payment of the loan dues, my lord, the same account is declared as NPA. Subsequently, proceeding under the Surface Act was initiated against the petitioner, my lord. Now, while initiating the proceeding and putting the property on auction, my lord, they have quoted some other property instead of the property which was a secured asset, my lord. And that fact was brought to the notice of the bank, and they did not turn up, my lord. Thereafter, my lord, I filed a civil suit before the learned civil judge junior division Bhubaneswar, my lord. And in that suit, my lord, I filed an application for injunction, my lord. That petition was taken into consideration, and learned trial court has found that since it is a proceeding under the Surface Act, the IA is not maintainable. Thereafter, I approached the learned second additional district judge Bhubaneswar, my lord, and that your lordship, I may draw your lordship's kind attention to 43, my lord, the operative portion of the order, my lord.
Submit, my lord. I have received the copy. I have instruction to appear. This is single bench matter, my lord, against order passed in the FAO by the court below, my lord.
No, you are coming against FAO?
Yes, my lord. That is the prayer I have seen it.
Let them registry verify it and place a report so that.
Yes, lord. As because it is Surface Act matter, for that reason, my lord, probably this matter has placed.
যেহেতু আপনি FAO অর্ডারটাও চ্যালেঞ্জ করছেন সিঙ্গেল বেঞ্চ রিলাই করি that is not that surface you are right.
Yes,
division bench matter
to set aside the
but
order
particular order passed is
Yes,
FAO ରେ ଯୋଉଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି
yes sir,
ସେଇଥିପାଇଁ so let a report be placed to them.
FAO 50 by 10 second.
ଲେଖନ୍ତୁ ଆପଣ ଫାଇଲ କରିଛନ୍ତି ନା ଇନଷ୍ଟ୍ରକ୍ସନ
Instruction में prepare करके काली फाइल कर
so and so submits that he has instruction to appear for both the opposite parties.
Yes,
for both the opposite parties, and he will file the wakalat nama by tomorrow, na? By tomorrow. The learning council, however, submits that since the petitioner is challenging the order dated 27/7/2024, passed by the London Second Additional District Judge Bhubaneswar in FAO number 15 of 2023 under Annexure 4. This matter is to be heard before one single judge. Let the registry place a note on this submission. And if it is a single bench matter, then it is to be assigned to the, it is to be placed before the assignment. Avasi or the otherwise it will come.
Okay.
Item 33.
33, your lordship, identical matter, your lordship has disposed of so many cases that is matter is pending before the competent authority and annexure 9. My lord, annexure everything is same.
তিনটা with
তিনটা, your lordship, everything.
Item 34.
May I please, Your Lordship? As a petitioner taken a home loan, my lord, given on time, now the petitioner challenge notice of issued by the opposite party number 1 dated 19/9/24 and 12/6 of 24. The petitioner and the co-borrower, Dr. Priti Naik, died since 26/2/22.
No, you are challenging what order? 19/9/2024 order.
Yes, my lord.
Notice.
Yes, my lord.
So please come to that notice. Says that thereafter 13/4 step has already been taken. So the proper authority or the quorum is to oppose the DRT, not this court. The possession has already been taken. It is mentioned in that order under section 13/4 of the Surface Act.
Yes, my lord.
So you have to oppose the alternative. Which alternative remedies available. Yeah. The decisions would have to be put for the disposal.
Item 35.
May it please your lordships. Since 2009, I had taken an agricultural loan. Then I couldn't repay the amount, and one-time settlement was done. All of a sudden, they started a surface proceeding in 23. I was not served with any notice, either 13/2 or 13/4, and I had given RTI to them, asking them, as well as the representation, asking them to serve me with the notice, which is under Annexure 3 and Annexure 4. However, the auction was carried out, and I could get on 7th of August the certified copy of the sell certificate.
So,
and then therein, my lords, after that I also got the valuation report. My humble submission before your lordships is that the event when I'm not getting served with the notices, I'm not being able to avail the remedy under 13(3)(a), nor I'm being able to avail my remedy before the learned DRT in any manner under section 17.
Same thing can be raised there for the DRT. All these
Mills,
things which you are saying.
I bowed on, Mills. There is one difficulty. May I just point out, Mills, that if they are not serving me with 13/4, the original copy,
it may so happen that they have got the proof with them. So that court may
let them
also
provide me with that, Mills. That may be provided to me so that I can avail my remedy.
Let it on alternative remedy available.
I have instructions after that.
Yes, the
bank may provide me with the documents.
Are Mr. So-and-so or counsel appearing for the Canada Bank.
Bank may provide me with the documents that your lordship
go to the alternative remedy, raise your all the points, including violation of principle of natural justice, that will be taken care of, and you have to substantiate it before that appropriate form. Yes, next.
One thing may just I bowed down to the lordships that 13/4 notice, if they could also serve to me, I can
So-
proceed with molesting.
Yes.
Item
Deputy.
36.
May I please, Your Lordship, that the petitioner has taken a loan of 62 lakhs. She could not pay, for which section successive proceeding has been initiated. And the collector has directed to take possession. Before the possession could be taken in the year 2021, she has deposited 60 lakhs of rupees. May I kindly glance to annexure 5, page 19. Now, as on 1/7/2024, there was 5,18,501 is the outstanding amount. The
Section
petitioner,
14 proceeding has already been initiated and that too in the year 2021.
yes, my lord.
So what is the status now?
Now, status, my lord, I have paid a substantial amount of 60 lakhs. Before they could take the possession, I have paid.
No, what is the latest development? How can we know that? এই যে 16/3/21 ଆପଣ notice-ଟା annex କରିଛନ୍ତି,
My lord.
that is under section 14.
Hello.
Right. So what happened thereafter?
Thereafter, I have paid 60 lakhs of rupees annexure 5, my lord.
No, you paid on which day?
I have paid on 21/12/2021.
So what is the development there?
Now they have did not take any possession. Now thereafter I am approaching them for a settlement. They are not listening to me, my lord. Just my only
Possession ଆପଣଙ୍କୁ ଏପର୍ଯ୍ୟନ୍ତ ନିଆ ହେଇନି?
No. Before that I have paid 60 lakhs. Before they could take possession. Now, my lord, annexure 5 outstanding on 1/7/2024, 5,18,501. I want to clear that
We are not on that. We are on that whether once this proceeding has been initiated, you can challenge it before another forum.
But I'm not challenging the proceeding. I'm not challenging the proceeding, my lord. My prayer is to clear up the dues under the OTS. They are not listening to me. That's the only.
Ultimately, once the bank gets the position, the bank can sell it to XYZ.
Yes, my lord.
So that perhaps that is the reason why they have approached the collector for that purpose.
My lord.
Under section 40.
Yes, my lord.
And that was in the year 2021. And what have you stated in your writ petition?
My lord.
That after this 14 proceeding was initiated before the collector, what is the status? Where have you stated?
Page, paragraph 8. I have stated it. I have deposited 60 lakhs of rupees.
Come to paragraph number 5. No.
Yes, ma'am. First, he refused to grant permission because of the agricultural land. Later, they have amended it and they have gone for the only house side.
See, come to annexure 2. In the last paragraph, it is mentioned that you are therefore requested to verify
the
your
record and submit a fresh application along with a fresh affidavit by mentioning the correct area of the land and to clarify as to whether the land is agriculture or not agriculture for taking further necessary action.
What happened thereafter?
Thereafter, they have filed the annexure 3 with affidavit.
Bank filed.
Bank filed.
Then what happened?
Then the annexure 4, they have given permission to take possession.
Annexure 4 is the some affidavit by the
no, my lord. Page 18.
That is the order by the authority.
Authority.
So already position is taken.
No, my lord. Position they have not taken. Before they could come and take possession, I have deposited 60 lakhs of rupees.
That means section 14 has been complied.
Complied. I am not that. On section.
They just come to that page, annexure 4.
My lord.
That is the copy of the order.
Copy of the order.
Passed by the collector.
Yes, my lord.
So pursuant to the provision under section so and so, and on consideration of the application so and so of the authorized officer, Bank of Baroda main branch so and so, the SDM so and so is hereby ordered to depot
executive magistrate who will remain present at the spot.
Yes.
To maintain law and order to take over the physical possession of the secured property as mentioned below. and to hand over the same to the authorized officer, Bank of Baroda, main
This
branch,
is again passed in 2021.
2021.
Then what happened?
Then, my lord, in the month of December 2021, I have paid them 60 lakhs rupees before they could take possession. That is the next Annexure 5, the account statement, madam.
So as such, you have not challenged this order.
No, I have not challenged the order.
You have not challenged, then what is the question of?
My lord, now I want
how can we entertain a writ petition in view of the Bafna Motors case?
No, my lord, my only prayer is to settle the account under the OTS. Now I have approached them, they are not listening to me.
That the language is very clear that once this thing has been done, no writ petition will be entertained. That is the language in that.
But once the possession has been
14 matter you are challenging, the forum is available. You can go to the DRT. Now, if you
I'm not challenging the 14, my lord. I am just praying for a direction to consider my OTS application. That is the only prayer, my lord.
It is up to them whether they will consider or not, because we are not, once this is brought to our notice that an order has been passed under section
I cannot suppress that, my lord. I cannot suppress that.
No, you should not also.
I cannot suppress.
This petition has been filed challenging the order dated so and so. And with a further direction.
Only
settle the loan account under the OTS scheme. In the case of Bokna Motorcycle, put for the paragraph, since the alternative remedy is available to the Swanson to challenge not only the order dated but also to adjudicate the prayer made in this Swanson.
I have not challenged that order, my lord.
They are not.
I have not challenged, my lord. I have not challenged the order under Annexure 4.
Because of this.
Only my prayer for OTS.
Order has already been passed. In view of the Bafna Motors case, it is not, and this prayer which has been made, that can also be taken care of by the alternative DRP. Therefore, we are not in time. That's next.
Item 37, my lord.
Item 37.
Senior counsel is appearing for the bank, my lord. The copy letter come after 15 days, my lord.
Who is to appear for this?
We are the just I have public copies.
If the land counsel for this one, Mr. Sarangi, senior advocate, has instruction to appear for the central bank, and he will file his appearance memo by tomorrow. Copy of the writ petition has already been served on these ones. Wants to take instruction on this matter. Matter will be listed next week. Acha. Matter will be listed on 15th January. Let it come on 15th January 2020.
We will appear for next week, Lord.
Acha, you tomorrow knowledge you appear by next week. I think he taking the name of the land senior advocate in the forum. Yes.
Item 38.
38 may please, Lord. The present petitioner prayed for seeking the direction to dispose of early disposal of the miscase. Section 14.
Page 19 again class. The office note could not be prepared because of filing of original documents. Unless the original document filed and verified with the petition filed.
Then the code function
page 19.
Page 19 and 20.
Page 19.
The continuous order passed by the learning by the district magistrate.
କେମିତି dispose of କରିବେ ଆପଣଙ୍କର
Lordship,
ଆପଣ
document is verified and compared with the petition
bank
filed by
authorities
the
are
bank.
every date.
ଆପଣ original document file କରିନାହାନ୍ତି, office note ହେଇନି, ଆପଣ କେବେ dispose of କରିବେ?
No, Lordship. The actual fact of the case, Lordship, in the year 2023, some documents are misplaced from the court. That's why the court authority had not received the original documents. Lordship, direct to receive and
କଣ କହୁଛନ୍ତି?
in the year 2023, some bank documents are misplaced.
That's why the court staffs are not receiving the original document.
Receiving not only on the date fixed,
Again,
they have to
local
show
and
the
finished doc-
original to compare by the bench clerk of the concerned dealing agent, it will be over.
Yes, that is
There
right.
is no requirement of submission of like other civil suits original to be filed.
ଆପଣଙ୍କର ଯଦି ବ୍ୟାଙ୍କ ମ୍ୟାନେଜର
ଆଜ୍ଞା
ତାର ଅଛି ଯୋଉ ସାର୍ଟିଫିକେଟ ଦେଇକି ଇସ୍ୟୁ କରିଦବ ଦିସ୍ ଇଜ ଦି ଟ୍ରୁ କପି ଅଫ ସୋ ଆଣ୍ଡ ସୋ ଦେନ୍ ଦ୍ୟାଟ୍ ଇଜ ଟୁ ବି ଜଷ୍ଟ ଭେରିଫାଏଡ ଆପଣ ଗୋଟେ ଜେରକ୍ସ କପି ବୋଧେ ଦେଇଛନ୍ତି ଯୋଉଥିପାଇଁ ସେ ଲେଖୁଛନ୍ତି ଯେ ଅରିଜିନାଲ ଡକୁମେଣ୍ଟସ ନଟ୍ ଫାଇଲ୍ଡ
No, Lordship.
ତେଣୁ
Back to pattern, Lordship. All the copies are as filed as true copy. But as
जो
per the
document is filed with
In any case, you have to comply 14(1).
Lordship,
So unless you comply, the bank cannot pass it. The Chief Judicial Magistrate can't pass an
Lordship,
order.
particular date not given in the court. That's why, Lordship, the bank suffers.
Why? Particular date means date order by order is there.
Yes, yes, Lordship.
Place this put up this matter on such and such date.
But Lordship, that
ସେଟା ଆଣିଲା ପରେ ପୁଣି କେମିତି ସେମିତି
yes, Lord.
submission କରୁଛନ୍ତି ଯେ date ଦିଆ ହଉନି ଆମକୁ
Every
Lord,
month
that
there
date
is a date.
they have not received the documents.
How can it be? The court will not receive the document.
Lordship, the officials are denied to.
No, it
Then
cannot.
they given a next date.
you are making ସେ CGM କୋର୍ଟରେ ଅଛି CGM କୋର୍ଟର ଗୋଟେ ଡାଏରୀ ମାନେ ଗୋଟେ ରେକର୍ଡ ମେଣ୍ଟେନ ହୁଏ ସେଠି ତାରିଖ ପଡୁଥିବ ଆପଣଙ୍କର କେସଟା ଇନଷ୍ଟିଚ୍ୟୁଟ ହେଇଛି ମିସ୍ କେସ୍ ନମ୍ବର ତାରିଖ କେତେ ପଡୁଥିବ କଣ ପାଇଁ ଅଛି ଆପଣ ଚାହିଁଲେ ଦେଖିପାରିବେ ଏବଂ ଏ ପ୍ରତ୍ୟେକ ଅର୍ଡର ସିଟ୍ ଦେଖଉଛି ଯେ କୋଉ ଡେଟ୍ କୁ କେସ୍ ରହିଲା ଆପଣଙ୍କ ଆଜ୍ଞା ସେଠି ଡେଟ୍ ପଡୁନି ସେଠି କିଛି ରିସିଭ୍ କରୁନାହାନ୍ତି ମୋ ଡକୁମେଣ୍ଟ ହାଉ କ୍ୟାନ୍ ଇଟ୍ ବି ଆକ୍ସେପ୍ଟେଡ୍ So this is actually this prayer cannot be unless you comply the remove the defects.
mandatory
Then no
requirement
direction can be issued. It is on your latches now. You comply then if it is delayed thereafter, then you can approach this court once again. Look, this writ petition has been filed by the petitioner Bank of India for a direction to the Chief Judicial Magistrate Khurda for early disposal of the petition filed under section 14 of the Surface Act registered as miscase number 24 of 2024. On perusal of the order sheet of the said miscase, it appears that the case was adjourned from time to time as original documents are not filed and it has been placed for office note. In view of such state of affairs, since there is laches on the part of the petitioner in not filing the original documents, no direction can be issued to the opposite party for early disposal of the so and so. However, it is made clear that if the petitioner complies the order and files the original documents, necessary steps shall be taken by the so and so for
date fixed.
30th expeditious disposal in accordance with law. Same order to be in the other case.
Lordship.
All. Both the cases are visible.
He filed a what a withdrawal.
What is the withdrawal?
Petitioner has filed a
disposal of the Mr. Anjan Kumar Biswa is present. The petition has filed for withdrawal of the writ petition. Disposed of his writ.
I am for the
ଆଉ
opposite
ଗୋଟେ
party.
କାଲି ପ୍ଲେସ୍ ଆଡମିସନ ଟା ପାସ୍ କରି ରହିଲା
I am for the opposite party.
As the opposite party.
Again.
Opposite party.
Petitioner
For the petitioner. Petitioner is present. ଆଉ ଯୋଉଟା ହେଲା କାଲିକି ଆସିବ ଆପଣ ନଥିଲେ
ହଁ ନଥିଲି ତ
କାଲିକି ଆସିବ
କାଲିକି ଡକା ହବ ନା ନେଇ ଆସିବି
କାଲି supplementary list
Automatic.
ଆଜ୍ଞା ଆଜ୍ଞା
Before my lord rises, my lord, item 9, my lord, had directed me to get a date from the Tahsildar. That date is 13/1/25. 13/1.
ସେଟା ସେମିତି ମେନସନ କରିଦେଇଥାନ୍ତୁ ଗୋଟେ ଗ୍ୟାପ ରହିଛି ଆଇଟମ ନମ୍ବର 9 ରେ ସେଠି କିଏ ଡିକ୍ଟେସନ ନେଇଥିଲେ ଦେଖିଦେବେ ସେ ଡେଟ୍ ଟା ପଡିବ 13/1 ତେଣୁ ଏଟା
Presence of the petitioner before the court.
let Mr. Rockhamudi into.
I'll inform. I'll.
From item number 30. From item number 35, my name may be deleted. File taken back 6 years back.
Why your name will be deleted?
When a file was taken in 2019 due to delay in listing, and now other aspects appeared. 35.
For delay in listing.
Minor. 6 years back. Then
So,
before 10 years,
if
it was not.
other council are not there,
File is not with me, my lord. I've given them file.
we will give you the file if the other council are not there.
My lord.
We will engage you as the amicus curiae to argue the matter.
My lord.
Right?
My lord.
Get ready.
My lord, I have
Are you
no
ready?
file. My lord, I know the matter, but I have no files.
Start arguing the matter.
My lord, no file, my lord.
Get the paperwork. We are providing you paperwork. Get ready. Tomorrow or day after tomorrow, we take up.
Day after
Sorry,
tomorrow, my lord.
not day after tomorrow. I mean, on next week we'll hear this.
My lord. If a brief is
Yes,
provided.
definitely it will be given.
In a pen drive, you can take it.
You can please give a pen drive.
My lord, give.
Just it will be given to you.
My lord.
Yes.
Beg your pardon, my lordship. The petitioner is inside the custody for more than 10 years.
Please give it.
Bail
application.
Published.
Weekly list item number 1.
Wait, please, Your Lordship. Your Lordship, to present appellant, although an order of interim bail was passed by this Honorable Court on 1/10/2024, however, he has availed the same in the month of December, Your Lordship.
So that period has not expired.
Yes, Your Lordship, that period is.
Right. The Land Council for the appellant submits that the period stipulated for interim bail has not yet expired, and the matter may be taken up in the month of February, so that surrender certificate will be filed. List this matter in the week commencing from 17th February 2025.
Yes, sir. Much obliged.
Item 2.
Last thing, Your Lordship, that is obtain the custody certificate, Your Lordship.
Yes, Mr.
My lord, obtain.
How many years is in custody?
15 years, 7 months, 8 days. Remission 2 years, 18 days.
Right. Actual custody period is
15 years.
15 years.
My lord.
So both this, there are two. No,
only Arjun.
Acha, Arjun. It is bail application is only for this Arjun.
Yes.
Arju Yasin.
Yes. Arju Yasin.
Alias Arju Yasin.
So whether earlier your bail application has been rejected?
No, my lord, this is first time.
First time.
Rejected in respect of what used?
No, we are concerned with this Arju.
My lord.
In this criminal appeal 745, there is only one appellant.
Yes.
That is Arju, right?
Yes.
So we want to know that whether his bail application has been rejected earlier in this criminal appeal or not.
No.
First time. So please come to the judgment, paragraph number 2.
Yes, yes. That the prosecution case is that
Why are you placing
paragraph 2.
Paragraph 2 of the info judgment?
Yes, Lord. The projected case of the prosecution during trial is that all the 3 accused persons being associated had made a plan to kill Firoz Ansari after kidnapping, abducting him,
and to demand ransom from his father. And according to their plan, on 23/4/2009 evening at about 6 p.m., accused Arju Yasing being associated with accused Ajit alias Sukru Seth called Firoz Ansari, who is the friend of Arju Yasin, to mobile phone near the cinema hall of Sundargarh to move somewhere, and according to the above call made by Arju Yasin's over mobile phone, the said Firoz Ansari came before them to his Hero Honda City Deluxe motorcycle bearing registration number so by telling his uncle and other family members that he is going to encash the challans of the truck, and when Firoz Ansari, reached before accused Arju Yasin and Ajit alias Sukru Seth near the cinema hall of Sundargarh, the said two accused persons took away Firoz Ansari towards RRIT colony of Sundargarh near Government College Road by the side motorcycle of Firoz Ansari and went up to the bank of river, which is a lonely place near horticulture Sundargarh. And after reaching there, while Firoz Ansari was talking to his mobile phone by sitting on his motorcycle, then according to the previous plan made by the accused persons, accused Ajit Seth gave a blow to the blown side of the chopper by MOV, which is used for cutting meat, which was taken by them without the knowledge of the Firoz Ansari at the backside neck of the Firoz Ansari with heavy force, and by the result of which Firoz Ansari fell down on the ground and vomiting blood, and thereafter accused Arju Yassin snatched away the said chopper by MOV from the hand of accused Ajit Seth and cut the throat of the Firoz Ansari while he was lying on the ground, and by the result of which Firoz Ansari expired there, instantaneously having sustained profuse bleeding injury. And after death of the Firoz, that paragraph.
Whether it is a case based on direct evidence or circumstantial evidence.
My lord, circumstantial evidence.
What are the circumstances which
My lord,
page it is
initially,
discussed?
my lord, initially the father of the deceased lodged the affair about missing kidnapping of his son, your lordship. Paragraph 19, my lord.
Paragraph page number?
Page 44A.
Internal page.
My lord.
Of which page of the judgment?
25.
25 to what now? Number 2. Paragraph 19. Sure.
12 circumstances basing on 12 that frame the approach.
Some of the circumstances are against the co-accused person.
Yes. Against the petitioner, incoming and outgoing call between the
there and
the weapon of offense was
weapon of offense was
recovered at the instance of the present petitioner.
That is circumstance number 4. It is stated.
And circumstance number 5, the driving license of the deceased and SIM card recovered from the possession of the present petitioner.
Specimen was and has been tallied.
and voice was also tallied.
This last scene, about this last scene, perhaps
through only mobile call.
This C has not been identified by in the TA period. By you come to column that paragraph number 8, circumstance number 8, identification of accused Ajit Seth by witness Papu Alam in the TA period.
Yes.
So that is perhaps not available against us. He has identified only one. Papu Alam is the witness number
866.
You got the last scene, no?
On dated 23/4/2009, night at about 11 p.m., accused Ajit alias Sukku said being associated with another had moved before my tire repairing shop at Badabahal, situated near Umesh Dhaba, with a puncture motorcycle, that is Hero Honda Deluxe, and with the back wheel pairwise puncture. Accused Ajit alias Sukku said requested me to repair the same through patch. Though another boy was pushing the puncture motorcycle held by accused to Ajit alias Sukru said, but the same boy who had give company to accused Ajit alias Sukru did not come to my tire puncture shop, and he went away a little distance of my shop by leaving the accused Ajit alias Sukru along with the puncture motorcycle. Accused Ajit alias Sukru said left the puncture motorcycle in my shop for its repairing and went to the nearest dhaba to have by that time I had already repaired his puncture motorcycle. Then accused Ajit alias Sukru said gave me 100 rupees towards the cost of the repairing and took away the repaired Hero Honda motorcycle from my shop and went away.
What when the occurrence took place?
And the occurrence took place on 23/4/2009 at about 6:30 p.m. As per the confessions.
Custody certificate again.
And the other two evidence were religion based violence.
No, he did.
Ajit said bail जाएंगे
on 24/11/2016.
Ajit said to white police you are a criminal offender. Inside question. केबे bail ହେଇଛି?
My lord, 24/11/2016 in Miss case number 1713 of 2016.
Hmm. Released from there.
24/11/16.
Ardil and Council. This is criminal appeal number 745 of 2011. Ardil and Council for the petitioner and Council for the state. And Council for the petitioner submits that the petitioner is in judicial custody for more than 15 years. And the case is based on circumstantial evidence. And the paperwork has already been prepared. There is no chance of early hearing. And the similarly situated co-accused, namely Ajit Seth, alias Sukru, was preferred. CRL number 321 of 2011.
So
Also,
Borun alias Nihar Kantamali.
Borun alias Nihar Kantamali in CRL number 574 of 2010. Have been directed to be released on bail by order dated 24/11/2016 and 17/7/2014 respectively. And therefore, the bail application may be favorably considered. When counsel for the state was asked to produce the custody certificate of the petitioner, and he has produced the same today, which also indicates that the petitioner has undergone more than 15 years of substantive sentence. The custody certificate is taken on record. When counsel for the state placed the impugned judgment, particularly where the circumstances appearing against the petitioner as well as the co-accused persons have been jotted down and discussed. After hearing the land and counsel for the respective parties, nature of evidence available on record, the period of detention of the petitioner, judicial custody, release of the co-accused persons on bail, we are inclined to release the petitioner on bail, sterilization of time.
Item 3.
Lordship. Just a minute.
Lordship.
Achieve this case, sterilization of time, it will be allowed. Yes.
Yes, sir. Milords, in this matter, I am through VC, Lordship.
Not audible, sir.
Lordship, my senior counsel has joined through VC.
Yes. You are not audible, sir.
Yes, my Lordship, in this matter, I am through VC, Lordship.
There is some glitch.
Not audible. Lordship.
Now you are.
Lordship, in this matter, I am through VC, Lordship. Lordship, we have filed an IF2 for interim bail to participate in the marriage of my sister. Milords, the factum of marriage has been verified by the police, Lordships, and the marriage has to took place tomorrow, Lordships. So in that context, we are just praying for the interim bail. And my specific prayer is there that I should be released on interim bail for at least, Lordship, 3 months because of the valid reason. Although the book is ready, paper book, but the most important documents like FIR 164 and 161 of 18 witnesses, they has not been translated. Lordship, I am not aware with the local language. So to be a lawyer in this matter, I will not be able to do justice with the case. So translation may take some time, and I have already suffered more than 13 years of punishment. And in this matter,
you, Mr. Manohar, let us be clear.
Lordship,
you want to be praise this application only on your sister's marriage, which is
yes, Lordship,
taken place tomorrow.
Yes, Lordship.
Merit you want to place this matter?
No, my lord. I am just I just want to take participant in the marriage. And further, since 13 years of carcination,
matter. Now you said that it has already been verified, all these things. Whether it has been verified. So you are a man from which area?
I am from Jaipur. A local person.
That's a local man.
Yes, Lordship. I am local man, and I don't have any type of antecedents, my lords.
IA number 3221 of 2024. This is an application for release of the appellant on interim bail on the ground of sister's marriage, which is fixed on
Third.
tomorrow, that is on
Tomorrow.
January 2025. The Learning Council for the state, as for the order dated 19/12/2024, has received the instruction from the inspector in charge of Patangi Police Station that the younger sister of the petitioner marriage is going to be held on 3/1/2025. You give it the Xerox copy of this. The document filed by the Learning Council for the state is taken on record. This is written instruction for this. Considering the submission made by the Learning Council for the respective parties, the grounds taken in the interim application, the written instruction received by the Land Council for the state, they are inclined to release the petitioner on interim bail for a period of 2 weeks from the date of release. The Land Trial Court shall not insist upon production of certified copy of the bail order tomorrow, today or tomorrow, for release of the petitioner on bail if an undertaking is furnished that the certified copy will be produced within a week. Bail order will be produced within a week. The order be uploaded immediately by the registry. The Learning Trial Court shall act upon uploaded orders of the High Court of Orissa. And the matter be placed on be commencing from such and such day. The Land Council for the financial surrender certificate. Yes.
Oblige Lordship. Lordship, may I pray for any for let the order be
After
uploaded?
surrender, you can file a race application. This is only meant for that.
Yes, Lordship. I bow down. I'm not praying for any other religion. Just praying let the order passed be
it
uploaded soon.
Itself. You
Okay. That's it.
Bailers to furnish the bail bond and.
That's it, Lordship. That's it. Obliged. Deeply obliged.
Item 4.
May not 2 weeks after to file the submission. Interim period is continuing. Just 1 week before the applicant has been released.
No. You have not produced the surrender certificate.
Interim period is continuing, my lord.
Oh, continuing. Right. The Land Council for the appellant submits that the interim bail period has not yet expired and the matter may be taken up in the month of February so that they will produce the surrender certificate of this matter in the commencing from 17th February 2025.
Item 5.
May I please?
On account of wife illness is suffering from cancer, now undergoing treatment at Acharya in critical condition ICU.
Any order was passed earlier for verification of the.
Yes, ma'am. The present start.
Yes, that was done in 16/12/2024. Acharya Harihar, postgraduate, Institute of Cancer, Cutter, she's an indoor patient.
I have
The-
filed that today's status, your lordship, the bed number, so far the central copy supplied.
ନା ନା ଆମେ ବୁଝିପାରୁନୁ ଆପଣଙ୍କର ଜଣଙ୍କର ସ୍ତ୍ରୀ କ୍ୟାନ୍ସରରେ ଇଏ କରୁଛି ସେ ଇନଡୋର ପେସେଣ୍ଟ ହିସାବରେ ଆଚାର୍ଯ୍ୟ ହରିହର ପୋଷ୍ଟ ଗ୍ରାଜୁଏଟ ଇନଷ୍ଟିଚ୍ୟୁଟ ଅଫ କ୍ୟାନ୍ସରରେ ଟ୍ରିଟମେଣ୍ଟ ହଉଛନ୍ତି 16/12 ଅର୍ଡର ହେଲା ଆପଣ ଭେରିଫାଏ କରିବେ ଏତିକି ଜିନିଷ ଆପଣ ଆଜି ଆସି 2 ତାରିଖ ହେଲାଣି ଆପଣ ଭେରିଫାଏ କରିପାରୁନାହାନ୍ତି କଣ କରାଯିବ we'll write it that this is the statement of the London additional government advocate ଆପଣ ସେ ବେଡ୍ ନମ୍ବର ଅନ୍ୟାନ୍ୟ ସବୁ ଡକ୍ୟୁମେଣ୍ଟ ଦେଇଛନ୍ତି
Rather, but that number I did not give it.
On the transfer of the IAC that has to be done. They are assured that they can provide me within 2. Today morning also contact.
what do you want us to do
Monday.
Monday, lordship, too late. I pray, lordship, tomorrow, lordship, because just now, lordship, got information. The deponent of this application has been contacted by the concerned.
ଇଏ କରିହବ ହଁ ଗୋଟେ ଦୂର ଜାଗା ଥାନ୍ତା ସେ ଫର୍ସ ଡିଷ୍ଟାନ୍ସ ମାନେ ଆପଣଙ୍କୁ ଯଦି ରେସ୍ପଣ୍ଡ କରୁନାହାନ୍ତି ଆପଣଙ୍କର ଆଇଆଇସି ମାନେ ଆପଣ କଣ କରିବେ ହଁ it is up to you how to take steps against them if they are this is an urgent matter and they move this application
Central ICU, bed number 314.
Action time verification paper.
ତାକୁ ଫୋନ କରନ୍ତୁ ସେ ଯୋଉଠି ଥିବ ଯିବ ସେଠିକି ଆଚାର୍ଯ୍ୟ ହରିହରକୁ ସେ ବେଡ୍ କୁ ପଚାରିବ ଆମେ ଅନ୍ୟ ମ୍ୟାଟର ନଉଛି ଟେକଅପ୍ କରିକି କହିବୁ we know how to set it things right IIC ମଙ୍ଗଳାବାଗ police station କୁ କୁହନ୍ତୁ ଆଚାର୍ଯ୍ୟ ହରିହର institute କୁ ଯିବ which is maximum would be at a distance of 200 meters away from his police station go to that bed ascertain whether that is the correct or not just get the information this is not the way to yes
Password.
Item 6.
And here, my lord, the London Council for the States was directed to take instruction as to date of appellant number 2 during pendency of the appeal and custody certificate of appellant number 1.
custody certificate
Yes.
Ginga Naik is dead.
Yes.
His appellant number?
2, my lord.
2. Custody certificate କେତେ ଦେଖଉଛି
4,952 days.
13 ବର୍ଷ 5 ମାସ ଟୋଟାଲ ଏଇଟା ଲେଖିଛନ୍ତି 13 ବର୍ଷ ଯୋଉ 5 ମାସ 4954 ତ
UTP ଭାବରେ 1602 days.
ହଁ ତାପରେ undergone as convict ତ A plus B plus E କି नहीं total That is also corroborated by the
Madam.
magistrate and
Madam.
mother and
PW10 is the executive magistrate. Running paper book, running page 79.
ବାହାଘର କେବେ ହେଇଥିଲା?
7 ବର୍ଷ 7 ବର୍ଷ ପୂର୍ବରୁ 7 ବର୍ଷ
What do you say? This is 9 they are recorded by the executive magistrate. Doctor certificate is there. What have you brought it in the cross-examination that you have put kerosene on your wife? Evidence is that she was in a fit state of mind, conscious, gave the damn declaration.
Date of occurrence manner 17/16 FR 23/16
ନାଇଁ ଏ ଡାଇମ୍ କ୍ଲାସ ବା ସେଇଦିନ ରେକର୍ଡ ହେଇଛି। ହଁ ଦେଖିଲେ ଆଜି ସେ କହୁନି ୱାର୍ଡିଂ ୟୁଜ ହଉଛି ଆଜି ଦିନ ମାନେ ସେଇଦିନ ରେକର୍ଡ ହେଇଛି। ଆଉ ଥରେ ଭାରତରେ ସେଟା ଆଜି ବୋଧେ ଗୋଟେ ୱାର୍ଡିଂ
22/26
ହଁ
22/26
23/ବାର ମାନେ PW 18 ମାନେ
No, no,
PW 18 ଟା doctor who conducted PM
17/12/2016 ହଉଛି ଡେଟ୍ ଅଫ୍ ଅକରେନ୍ସ ହେଲା। ସେଇଦିନ ମଧ୍ୟ ସବୁ ୱିଟନେସ୍ ମାନଙ୍କର ଡାକ୍ତର ଏମାନଙ୍କର ସିଗ୍ନେଚର ତଳେ ଡେଟ୍ ବି ପଡିଛି 17/12/2016 ଏବଂ they are also doctor's certificate has been given in the above of that Dr. V. Rajesh was also been examined. It is to certify that the patient Sangeeta Bisoi, aged about so and so, is clinically stable and oriented to time, place, and person to give her dying declaration. So dying, so ଏଗୁଡାକ ରହିଛି। ଆପଣ ଯୋଉ ପ୍ଲିଟା ନେଇକିନି ଜଣେଇଥିଲେ ଆପଣଙ୍କର ଶାଶୁ ଆଉ ଘର ଲୋକଙ୍କୁ ଷ୍ଟୋଭ ଫାଟିଗଲା ବୋଲି ସେ ଷ୍ଟୋଭ ଯୋଉ ଜବତ ହେଲା ଦେଖାଗଲା ସେ ପୁରା ଅକ୍ଷତ ଅବସ୍ଥାରେ ଅଛି, କିଛି ଖରାପ ହେଇନି।
Total siege corner PW20
total siege in exhibit
PW20
3 is the seizure list
PW20 IO
that has been proved as exhibit 3 ଗୋଟିଏ ସବୁଜ ରଙ୍ଗର ପ୍ଲାଷ୍ଟିକ ବ୍ୟାରେଲ ଯେଉଁଥିରେ ସୁଆଂଶୋ, ଗୋଟିଏ ଷ୍ଟୋଭ ଯାହାର ଟାଙ୍କିରେ ଠିପି ନଥାଏ, ଗୋଟେ ଦିଆସିଲ ପେଡି ଯେଉଁଥିରେ କିଛି ଦିଆସିଲ ଥାଏ। ଉପରୋକ୍ତ ମୋକଦ୍ଦମାରେ ସୁଆଂଶୋ ସାକ୍ଷୀ ମାନଙ୍କ ସାମ୍ନାରେ ଜବତ କରି ଜବତ ତାଲିକା ପ୍ରସ୍ତୁତ କରାଗଲା। ଜବତ ତାଲିକା ଜବତ ହେଇନି କଣ କି 23 ତାରିଖ ଦିନ ଜବତ ହେଇଛି। ବାସଗୃହରୁ ଆସାମୀ ସୁଶାନ୍ତ ବିଷୟଙ୍କ ବାସଗୃହରୁ ଜବତ ହେଲା। So your wife was with you in your house. She sustained burn injuries and you intimated to her family members that it is on account of bursting of that stove that she received the injury, which was found to be not correct in view of the seizure list of that stove number. Next thing is that your wife gave the dying declaration before the magistrate in presence of the doctor, and where she has indicated that you are the person who set fire off after pouring kerosene. This is the dying declaration.
Page 17 of the judgment matter. Page 17 of the judgment matter.
Judgment. Page 17.
26 of my opinion.
Just a minute. हाँ 17 में कौन है?
He has acknowledged that the criminal detail from the criminal detail form does not maintain the motive. He has affirmed the statement of the informant about physical. Just page 17 of the judgment, appeal number 26, first line.
हाँ
He has acknowledged.
First line.
He has acknowledged that the crime detail form does not mention the motive. He has affirmed the statement of the informant about physical assault on the deceased by her husband. He has admitted that
Which portion of the
minor judgment page 17 minor.
17?
17 minor.
Page?
Minor.
Paragraph?
Paragraph
first line.
The 7 room.
Paragraph
Paragraph
7
7
of judgment.
Paper book ଟିକେ
Paper book ରେ ଅଛି?
paper book page numbering করতে হলে
Appeal memo minor page 16 minor.
Just a minute. 15 ପରେ 16 ଅଛି, 16 ପରେ ଅଛି,
19 19 ପରେ 20 ତାପରେ 17
ତାପରେ ଅଛି କି? ଏଇ 17 ପେଜ ରୁ କହୁଛନ୍ତି ଆପଣ? ଯୋଉଟା କି ଇଏ ସିରିୟଲ ନମ୍ବର ଭୁଲ ହେଇଛି, 29 ହେଇଛି ସେଟା ରନିଂ ପେଜ। କୋଉ ପାରାଗ୍ରାଫ କହୁଛନ୍ତି? He has acknowledged. ଏଇ ପେଜ ନମ୍ବର 29 ଯୋଉଟା କହୁଛନ୍ତି ରନିଂ ପେଜ, ଏଟା 17ଟା ପରେ ଅଛି। ସିରିୟଲି ନାହିଁ, ଏଟା ସିରିୟଲି ଭୁଲ ଭାଲ ହେଇଛି, ତା ପର 2 ପେଜ ପରେ ଅଛି। 29 ଯେତେବେଳେ ସେ ପେଜଟା 29 କଣ ପଢନ୍ତୁ କଣ?
My lord, he has acknowledged that the crime detail form does not mention the motive. He has affirmed the statement of the informant about physical assault on the deceased by her husband. He has admitted that widowed one did not disclose to her about any dowry demand or torture for dowry, and that he had not examined the signatory of the dying declaration, the mother and the mother-in-law of the deceased. She has
IO को cross examination
IO को ଏତିକ ବାହାର କରିକି ଆଣିଛନ୍ତି ଯେ
ଆରମ୍ଭ ହଉଛି page 15 P20 being the IO ସେଇଟାର ଏଟା continuance.
He has affirmed his denial about any fire explosion of the old stove resulting in the victim catching fire, hearing which the accused rushed to the spot and also sustained burn injury on his face and hand, and the denial of the accused not responsible for the death of the deceased. And 16, page 16, my lord. Middle 8 lines after. He has admitted that page 16.
16
He has admitted that the FIR did not reveal a single word about the torture dowry demand made on the deceased victim. That he did not requisition scientific team to the investigation for collection incriminating materials from the spot. He has acknowledged the initiative by the accused and her family members for the treatment of the victim, the receipt of the dead body by the matrimonial relatives for the ceremony.
You see, you are not facing any trial either under section 304B or section 4 of Dowry Prohibition Act. ତେଣୁ ସେ ବିଷୟରେ ତାଙ୍କର ଚାର୍ଜ ହିଁ ନାହିଁ ଆପଣ, but charge ହଉଛି 498A 302 406, right? And you have been 406 you have been acquitted, you have been found guilty under 498A and 302, ଠିକ ନା ନାହିଁ? ତେଣୁ ବର୍ତ୍ତମାନ ଆପଣଙ୍କ ଏଗେନ୍ଷ୍ଟରେ ଏତିକି ମ୍ୟାଟେରିଆଲ ଅଛି ଡାଉରୀ କଥା ଏଠି ଉଠୁନି, ଡାଉରୀ କଥା କହନ୍ତୁ ବା ନ କୁହନ୍ତୁ, ଆଉ ମୋଟିଭ ଏ ଯୋଉ ଡାଇଂ ଡିକ୍ଲାରେସନରେ ଯାହା ରହିଛି ସେତିକି ପାଇଁ ଯଦି ଆସିଲା, ମୋଟିଭ କଣ ଦରକାର ଏଠି? ମୋଟିଭ ଦରକାର କି ଗୋଟେ ଆପଣ ସ୍ତ୍ରୀକୁ କଣ ପାଇଁ ପୋଡ଼ିଲେ, ସେଇଟା ଯଦି ପ୍ରସିକ୍ୟୁସନ ନ ଆଣିପାରୁଛି ବା ସ୍ତ୍ରୀ ସେ ପୋଜିସନରେ ନାହିଁ ସବୁ ଜିନିଷ ଡିଟେଲି କହିବାକୁ, can it be disbelieved that denying declaration merely because she has not made a detailed why it took place and what was the reason and how many times she has previously assaulted? Somebody is dying on the verge of the dates, and she is making a statement like this. ସେ ପିଲା ଦିଟା କଣ କରୁଛନ୍ତି?
ଆମ ପାଖରେ ଅଛନ୍ତି।
ଆମ ପାଖରେ ମାନେ କାହା ପାଖରେ?
ବାପ ମାନେ ଫାଦର ଗ୍ରାଣ୍ଡଫାଦର ପାଖରେ।
ଗ୍ରାଣ୍ଡଫାଦର। କେତେ ବର୍ଷ ତମ ହେଲାଣି?
ଆମକୁ 12 ବର୍ଷ ଏବଂ 8 ବର୍ଷ 9 ବର୍ଷ। That instruction is not with me.
ସେଟା ଟିକେ ଆଣୁ ଦେଖିବା। You are producing the custody certificate today. The Land Council for the appellant.
7 years 9 months.
Produce the custody certificate which is taken on during course of the bail application hearing. The Land Council for the appellant submitted that the appellant is the husband of the deceased, and they are having 2 children, and both of them are prosecuting their studies in school. And they are staying in the house of the appellant with their grandfather. Let the Land Council for the state obtain instruction in that respect. Put up this matter in the commencing from 20th of
Item 10.
Yeah, please, ma'am. My lord, I filed a new Allotment in this case.
New Allotment means kahan are you?
Sushant Kumar Samantara.
Your name is Sushant Samantara?
No, associate.
You are an associate of Sushant Samantara.
One request, my lord.
Here is the prisoner's petition at flag A and flag B regarding engagement of Mr. Sushant Samantara as his advocate. Mr. Samantara has filed Wakalatnama, which is accepted. The name of other counsel except Mr. Sushant Samantara and his associate shall not be reflected in the cause list henceforth.
My lord, on request, my lord, paper book.
Paper book has been prepared. Like you have got power in this case.
Yes,
what is your name?
Sivananda Maharani. Yes, Maharani.
Yes, Maharani. As a movement, it is Sivananda Maharani permission college. And he is an associate of Sushant Samantara. Mr. Maharana submits that he has not received a copy of the paper book. Stop. Paper book actually. You please wait. He will hand over you the paper book. Let a copy of the paper book be handed over to the Land Council for the appellant.
Okay.
So anyone is ready in this time? कितने नंबर
5 pages.
The case, Mr. General.
The case also, there is civil dispute to brothers also. And
your bail application has been rejected earlier. Twice.
So far only appellant Murtunjay Patra is concerned, others have been considered.
No. Here you are applying for bail for whom?
Interim bail for Murtunjay Patra.
Murtunjay Patra.
Yes, sir.
So Murtunjay Patra's bail application has been earlier rejected.
Yes. Thereafter, he has been twice released interim bail for one is suffering from eye disease for
single murder or double murder?
Double events.
Double murder. Which area?
That is a lordship under the Rasmundri police station, Mohanmanji. And now I am in agitated your lordship 81 years.
81.
Yes, my lord. Remaining custody 15 years.
IA number 3203 of 2024. This is an application for interim bail on the ground that the wife of the petitioner is suffering from cancer and is undergoing treatment as an indoor patient in Acharya Harihar Postgraduate Institute of Cancer, Cuttack, in 6/12/2024. Documents relating to the treatment of the wife has been annexed to the interim application as Annexure 1 series. The Learning Council for the state was asked to obtain instruction on this interim application, and he has received instruction. That the wife is suffering, wife of the petitioner is suffering from cancer, and she has been admitted as an indoor patient. The Land Council for the state has produced the indoor case sheet of so and so, which is taken on record. So, the Land Council for the petitioner further submit that the petitioner is it about 81 years?
No, but the record doesn't say so.
73 age your lordship plan the
73 is another person. Then
पर मुत्युंजय your lordship plan तो
yes, 68, 69.
मुत्युंजय जजमेंट केते लिखा है
Judgment 58 ଅଛି
58 is
14 ରେ
April में is file 73 your lordship.
say 70
years for them, hello, and he may be granted he may be granted to interim bail for fully part of the The Land Council for the petitioner has also filed affidavit, additional affidavit relating to the elements one. It was still liquid. Separate as considering the submission made by the Land Council for the petitioner, taking into account the arguments taken in the interim application, the documents submitted to the interim application, and the instruction obtained by the sponsor. We are inclined to review the petitioner on interim bail for a period of 3 months. The matter will be listed in the summons for a proposal by the summons.
Guardian copy lordship.
Yes, sir.
Delivery. As per judgment your lordship 74 years, but now is actually age 81 years.
Judgment पर 58 लिखा है जी
58 वाले 2024 और 74 years.
अपना 74 तक
हाँ. So anyone is ready, Mr.
Item 19, my lord, 81.
You have received the copy of the paper book.
My lord,
19.
my lord.
Right.
Item 70.
70. So admission also there, sir.
In this case,
We thought that in.
yes,
Yes,
I was engaged as amicus.
No, it's all right. So item number 17 ने कौन है जी कौन है?
In item 17, I was engaged earlier.
हाँ नहीं नहीं.
On 19/11/20 रे ମୁଁ receive कली.
No, we are not on that. This matter has not yet been admitted.
Yes, sir.
But all the same paperwork has been prepared.
No, 20 ତାରିଖରେ ମୋତେ ଖାଲି judgment copy ଟା ଦେଇଥିଲେ.
ଠିକ ଅଛି.
ପାଇନାହାନ୍ତି?
ହଁ 20 ରେ receive କଲି. ଏଇ 20.
Right, ଏଇଟା କରିଦିଅନ୍ତୁ. ଏଇଟା କଣ 302 case ତ?
Yes, sir.
Hard admit.
ସେଥିରେ ଗୋଟେ prisoner person.
Wait.
Yes, didn't ask me.
Call for
It can
the
be LCR as
call for the trial court record. Admit hello. Call for the trial court record. The prisoner petitioner is issued as to answer for engagement of Mr. Sapan Kumar Pal. In this contest, Sapan Kumar Pal has filed. Where is he park? ନାହାନ୍ତି ତ ଆପଣ କରିବେ ଆଉ କଣ ହଉଛି ନା ଥାଉ ଆପଣ ମୁଭ୍ କରନ୍ତୁ ଆପଣ କଣ ଦରକାର ଆଉ କଣ you take it, let the LCR come.
Yeah.
The trial court record is not there. It will come and then you will be supplied with that. Yes. Now come to the second one, item number 18. It will be admit hini. No. It will.
LCR अच्छी paper will be.
अच्छा. ये actually council की है. P02. Hard admit trial court record for SC. Paper will be ready. Yeah, Guru Thile Leki appears for the appellant level. Yes, Ms. Sahu, you are ready? Item number 19. Conviction under section
302, my lord.
302 and 324 are the two charges.
302 and 324, my lord.
So there must be an eyewitness to the occurrence.
My lord.
So that 324 जो assault ही थी कहाँ पर assault ही जो में 324 अपन को conviction है
Injured, one of the injured, my lord, and PW3, my lord.
PW3.
My lord.
So he is an eyewitness to the occurrence, but
My lord.
him
Two eyewitness in this occurrence, my lord. One is PW3 and other is PW6, my lord, who is the son of the PW3.
Okay, these are the two eyewitnesses.
My lord.
And who are the doctors?
Doctor conducted the PM, my lord, PW4, my lord.
P4. PW7 and injured doctor. FIR question.
Informant PW1, my lord. Will also
Pradhan is PW1.
My lord.
Yes.
ନିବେଦନର ଅଭିପ୍ରାୟ ଏହିକି ମୁଁ ସୁଲଭ ପ୍ରଧାନ ପିତା କାନ୍ଦୁରୁ ପ୍ରଧାନ ସୋରିଷିଆପଦା ଢେଙ୍କାନାଳ ଆଜି 27/2/2009 ଶୁକ୍ରବାର ସନ୍ଧ୍ୟା 6:30 ସମୟରେ ଏକ ଟେଲିଫୋନ ପାଇଲି ମୋର ବଡ ଭାଇ ଶ୍ରୀ ମାଧବ ପ୍ରଧାନ ପିତା କାନ୍ଦୁରୀ ପ୍ରଧାନ ସୋରିଷିଆପଦା ଗ୍ରାମର ଶ୍ରୀ କ୍ଷୀରୋଦ ଦେହୁରୀ ଗୋଟିଏ କ୍ଷୀରୋଦ ଦେହୁରୀ ନା ଅପିଲାଣ୍ଟ କ୍ଷୀରୋଦ ଦେହୁରୀ ସରି ମାଧବ ପ୍ରଧାନ
ମାଧବ ହଁ ତାହେଲେ ଇଏ ହଉଛି ମାନେ ଇନଫର୍ମାଣ୍ଟ ହଉଛି ତାର ସାନ ଭାଇ ଡିସିଜ ର ସାନ ଭାଇ ଆଉ ଥରେ ପଢନ୍ତୁ ଟେଲିଫୋନରେ କଣ ଖବର ପାଇଲା
ଟେଲିଫୋନରେ ପାଇଲି ଯେ ମୋର ବଡ ଭାଇ ଶ୍ରୀ ମାଧବ ପ୍ରଧାନ ପିତା କାନ୍ଦୁରୀ ପ୍ରଧାନ ବୟସ 38 କୁ ସୋରିଷିଆପଦା ଗ୍ରାମର ଶ୍ରୀ କ୍ଷୀରୋଦ ଦେହୁରୀ ଗୋଟିଏ ଚଉଆସିଆ କାଠରେ ତାଙ୍କର ମୁଣ୍ଡକୁ ହଠାତ୍ ବାଡେଇବାରୁ ତାଙ୍କ ମୁଣ୍ଡ ଫାଟି ବହୁତ ରକ୍ତସ୍ରାବ ହୋଇଛି ମୁଁ ଏ ଖବର ପାଇ ସୋରିଷିଆପଦା ଗ୍ରାମକୁ ଯାଇ ଦେଖେ ଯେ ମୋର ବଡ ଭାଇଙ୍କ ମୁଣ୍ଡରୁ ବହୁତ ରକ୍ତ ବାହାରି ରାସ୍ତା କଡରେ ଗୋକୁଳ ଦେହୁରୀଙ୍କ ଘର ସାମ୍ନାରେ ପଡି ରହିଥିଲେ ମୁଁ ତାଙ୍କୁ ଡାକିବାରୁ ସେ କିଛି କଥା କହିପାରିଲେ ନାହିଁ ତେଣୁ ତାଙ୍କର ଚିକିତ୍ସା ପାଇଁ ସଙ୍ଗେ ସଙ୍ଗେ ଗାଡି ଭଡା କରି ଢେଙ୍କାନାଳ ଡାକ୍ତରଖାନା ନେଇ ଗଲୁ
ସେଠାରେ ଡାକ୍ତର ବାବୁ ଦେଖାଇବାରୁ ସେ ମୋର ବଡ଼ ଭାଇ ମାଧବ ପ୍ରଧାନ ମରିଯାଇଛନ୍ତି ବୋଲି କହିଲେ। ଉକ୍ତ ଘଟଣା ସନାତନ ବେହେରା, ତାଙ୍କ ପୁଅ ପବିତ୍ର ବେହେରା ଓ ଅନ୍ୟମାନେ ଦେଖିଛନ୍ତି।
କିଏ କିଏ ସେ ଦି ଜଣ?
ସନାତନ ବେହେରା is the PW3 my lord and another
ବେହେରା ହେଲା PW3
my lord.
ଆଉ ତା ପୁଅ
ତାର ପୁଅ ପବିତ୍ର ବେହେରା PW6 my lord.
6
my lord.
ଆଚ୍ଛା, ଏଇ ଦି ଜଣ ହଉଛନ୍ତି ଆଇ ୱିଟନେସ୍।
my lord.
ତ ତା ଦେହରୁ ଇନଜିଓର୍ଡ ହେଲା PW
P7 no my lord. Injured ହେଲା son of the PW3 PW3 my lord.
PW3 ହେଲା injured.
my lord.
So now you straight come to PW3.
my lord. Relevant person my lord, para 3 my lord. my lord. At that time, deceased Madhav Pradhan was returning from the soap towards his village in his bicycle. The accused Khirod Dehuri suddenly came to the road holding a wooden plank having 4 side surface. He went near Madhav and suddenly dealt a blow by that wood on the back of Madhav, who fell down. Again, Khirod dealt a blow with that wood on the head of Madhav, causing bleeding injury, and result thereof he lost his sense. I tried towards the next blow aimed by Khirod. He chased me and dealt a blow
I
on my
tried
back.
to ward off
I tried to ward off
The next blow aimed by Khirod. He chased me and dealt a blow on my back and waist by the said wooden plank. I turned towards the accused and forcibly captured him. In that process, the accused beat me on my right hand by his teeth. The blow aimed by the accused to my head hit me on the back. He stated that only one blow, my lord. On the eyewitness stated that one blow. One blow to the deceased and another blow to the injured, my lord.
Again, please come once again.
My lord. He went near Madhav and suddenly a blow by that wood on the back of Madhav, who fell down. Again, Khirod dealt a blow with that wood on the head of Madhav. My lord, causing bleeding injury.
ହାର୍ଡ ବ୍ଲୋଟାକୁ ଇଏ ୱାର୍ଡ ଅଫ୍ କରିବାକୁ ଚାହୁଁଥିଲା,
My lord.
ଯୋଉଟାକୁ କଲା ଏବଂ ତା ଦେହରେ ଇଞ୍ଜୁରି ସଷ୍ଟେନ୍ କଲା ବୋଲି। Alright, you come to paragraph 4.
My lord. Villagers gathered and overpowered the accused. I sustained small injury on my hand and back due to the blow given by the accused, and for the same I had received treatment at the hospital at Barpada. I was examined by police during investigation. MO is the wooden plank having 4 sides and edges by which the accused had assaulted the deceased and myself. Madhav was taken to the hospital for treatment where he died, my lord.
Did read the cross-examination.
My lord. Distance of village Chaulia from my village will be 1.5 kilometers. Sarojia Pada Bajar, situated at a close distance from my house. There is a shop at a distance of about 200 meters from my house. My house about the village road, and there is a small fence on the backside of my house having little height and opening at place for egress and ingress.
Egress and
Egress, my lord. Egress and ingress. 4 families are residing in that locality. Gokuli Dehuri, his wife Firika Dehuri, Nauri Dehuri, and his wife one Tulia Behera and Papa Behera are residents of my Sahi besides. Some persons are residing there. Many persons of the village witnessed the occurrence. For the male members of my Sahi having not returned from from work had not witnessed the occurrence. But the female members of those homes came to the spot after the alleged assault. They came to the spot half an hour of the alleged assault, and none came to the spot within the first half an hour. After the first assault, the sarpanch of the village was not present at the spot. I never met the sarpanch after the occurrence. One Devraj Sahu is the proprietor of the shop situated near the spot. When we raised hula, seeing the act of the accused, many persons gathered at the spot. Arjun Pradhan and Nauri Dehuri of my village came to the spot hearing hula. The accused came with I from the
MO1.
MO1 from the direction of his house. The family of the accused consists of his wife, two sons, elder brother, brothers of wife, and sons. In the backside of my house, I have my private road to approach the fields. My neighbors used to utilize that road to approach the bathing hatter. Occasionally, people use that road. The house of the accused situates at one of the village. I cannot assign any reason why the accused assault the deceased. I have not gone near the deceased to count the injuries sustained by him. The cycle of the deceased was laying near the place of occurrence. That was a Kucha road. On the date of occurrence, the road was having potholes. On the occurrence night, police came to our village and recorded my statement. Being advised by police, I went to the PS on the next day and police sent me for medical examination at about 3 p.m. of that day. Soon thereafter, I left home. I cannot say what was the health condition of the deceased during that time. On the next day, I heard about Madhava's death. I cannot say what happened to the deceased during that night since I was having pain on my body due to the assault caused to me. During the night of occurrence day, I remained at home without taking any medicine. Since my son was not at home, I could not go to hospital. On the next morning, today for the first time, I am deposing about the alleged occurrence in the court. The accused was earning his livelihood as an agricultural labor. It is not a fact that Kirod had not assaulted Madhav. The wooden plank produced in the court today was shown to me by police. MO1 does not contain my signature. It is also not a fact that the accused had not assaulted the deceased by MO1. It is not a fact that due to the accident made by Madhav being dashed against my grandson, he fell down on the road and due to contact on the cycle of the road sustained injuries on his head and Madhav became senseless at the spot, and when the accused came to the spot and tried to ascertain the situation and thereon thereof, I blamed him as the assailant and called others and declared that the accused assaulted Madhav. The articles which Madhav was carrying were laying scattered on the road. Scattered on the road. It is not a fact that at the behest of the local sarpanch, a false case has been initiated against the accused for this gross born during the last election. This is the cross-examination, my lord.
Who is the doctor who conducted PM? PW4?
PW4, my lord. Who conducted with
notice?
PM.
Hold on.
My lord, I have a glance on the para 3, lacerated injury, 3 injuries there, my lord. I have a glance on the para 3, my lord.
Frontal bone of this skull, temporal bone of this skull, and occipital bone of this skull.
My lord.
All the three are on the head.
My lord. On para 3, my lord, on the last person, you has stated that the probable cause of death was damage caused to the brain leading to severe hemorrhage and the injury found by me appears homicidal in nature. But the injury found on the head of the deceased might have been caused by a wooden substance of Thenga. Might have been. It was dictated as might have been.
No, the next sentence is
the injury found on the head of the deceased might have been caused by a wooden substance. The MO1.
MO1 was shown to him.
My
It was sent by the IO for examination and giving. So he
wooden
said
plank having 4 size of edge can cause injury which were found on the skull. Well, let have a glance on the para 4 also on the cross examination. The doctor said that I had no scope of examination the alleged weapon of offense, nor any such weapon was produced before me by the IO for my observation.
So it was produced for the first time.
My lord.
It was shown to him during trial.
My lord.
But how do you get over the evidence of injured witness whose presence at the scene of occurrence cannot be disputed? what have you brought out in the cross-examination so that we'll have doubt that he is not a truthful witness and he is deposing falsehood?
Both the eyewitness, my lord. One eyewitness was said that one blow, and another witness said that two blow, my lord. Have a glance on the another
This
eyewitness.
witness, at least PW3 has stated about two blows.
Two blows.
So PW6 has stated about one.
One blow, my lord.
What is that? PW6.
My lord. Para 2, my lord. Suddenly, Khirod dealt a blow to Madhav by the wooden plank held by him. Madhav sustained injury on his head and fell down. When Madhav fell down, having sustained bleeding injury, my father Sanatana tried to prevent the accused assaulted further to Madhav, but the accused chased to assault my father.
UP has stated that the appellant dealt one blow.
My lord.
So why did you put this question in the cross-examination? Fourth, fifth line from the top of the cross-examination in paragraph number 5.
My lord.
He's giving a very lucid explanation to it. First blow was given on the back. When Madhav fell down, the other blow were given on his head.
What type of cross-examination is this? In the chief examination, the witness is telling that just one blow has been given, and in the cross-examination, you have not only elicited that 3 to 4 blows were given, but on which part it was given, how it was given, why it was given, all these things have been brought it out. So that is why it is always told that cross-examiner counsel should know what not to ask first, then what to ask.
Another thing, my lord, motive was not proved by the prosecution, my lord.
Direct evidence.
Direct evidence, what is the motive is not known.
As per the statement of the informant, also it is a doubtful, my lord. Have a glance on the affair, my lord. Not a single line stated against the serpent that he was dictated the affair, and the same affair was lodged by the PH, my lord. On the affair, my lord, have a glance on the affair, page 25, my lord. The informant stated that ମୁଁ ଏ ଖବର ପାଇ ସୋରିଷିଆ ପଦା ଗ୍ରାମକୁ ଯାଇ ଦେଖେ ଯେ ମୋର ବଡ ଭାଇ ମୁଣ୍ଡରୁ ରକ୍ତ ବାହାରୁଛି, ରାସ୍ତା କଡରେ ଗୋକୁଳି ଦେଉରୀଙ୍କ ଘର ସାମ୍ନାରେ ପଡି ରହିଥିବା। ମୁଁ ତାର ଡାକିବାରୁ କିଛି କଥା କହିପାରିଲା ନାହିଁ, ତେଣୁ ତାଙ୍କୁ ଚିକିତ୍ସା ପାଇଁ ସଙ୍ଗେ ସଙ୍ଗେ ଗାଡି ଭଡା କରି ଡାକ୍ତରଖାନାକୁ ନେଲୁ। ସେଠାରେ ଡାକ୍ତରବାବୁ ଦେଖେଇବାରୁ ସେ ମୋ ବଡ ଭାଇ ମାଧବ ପ୍ରଧାନ ମରିଯାଇଛନ୍ତି କହିଲେ। ଉକ୍ତ ଘଟଣା ସନାତନ ବେହେରା, ତାଙ୍କ ପୁଅ ପବିତ୍ର ବେହେରା, ଅନ୍ୟମାନେ ଦେଖିଛନ୍ତି। ସନାତନ ବେହେରା ଛଡାଇବାକୁ ଯାଇ କ୍ଷୀରୋଦ ବେହେରା ଦ୍ୱାରା ଉକ୍ତ କାଠରେ ମାଡ ଖାଇ ଆଘାତ ପାଇଛି। ମୋର ଭାଇ ଘରକୁ ସଉଦା କିଣିବା ପାଇଁ ଯାଇ ବାଟରେ ଫେରିବା ବେଳେ ଏହି ଘଟଣା ଘଟିଛି। But as per the statement of PW5, my lord, who was the sarpanch in that area, who lost the affair, not a single line stated against that. The sarpanch was lost the affair. But he was stated at that statement that informant himself stated that I lost the affair. Not a single line stated regarding the PW1, my lord.
Mr. Pradhan, there is nothing as to why that man assaulted the deceased. They were co-villagers, no? So, is there anything on record? We are aware that it is not necessary to prove the motive, but just out of, because he's making a submission that there is nothing on record regarding motive. So, is there anything? Have you gone through this paper book? So any of the witness has stated any kind of previous dispute between the parties that relating to any kind of thing, let us say land dispute or anything. Yes. What the witnesses have stated. Wife of the
Defense witness.
Regarding that, no such document produced before the trial. TW1, my lord, on the
TW1
CP3.
केवल कहले my husband is a mentally ill person
My lord.
and never works to earn his livelihood. That there are 60 houses in the valleys, panchayat situates. I used to work in. Nowhere she denies the assault to have been made by her husband. She is not denied. Only statement that my husband has been falsely implicated in this case because of political rival.
Political rival action. Two witness can. Only one witness. No, one witness.
One also stated a wooden leg of court, my lord.
So the doctor who has conducted the postmortem examination,
My lord.
though he has noticed as many as 3 injuries
My lord.
on the skull.
My lord.
Okay.
My lord.
And he has stated that this parietal, occipital, frontal bones have been fractured.
My lord.
Brain matters are damaged.
My lord.
Has he given any statement that these injuries are sufficient in ordinary course of nature to cause death?
Doctor only stated that might have been, but sufficient actually
No.
No, injuries
might have been.
Head of the disease might have been caused by a wooden substance.
No, it's not that
about the
that's sufficient in ordinary course of nature to cause death. So that statement, let us say, that is not there. So whether anything can be done in that person has assaulted on the head, given, let us say, if the evidence of these witnesses are accepted, so it amounts to 3 blows because one is on the occipital bone, the other is on the right and left frontal, another is on the right. So anything has been brought out that whether a single blow can cause all these injuries or for that 3 separate blows are necessary. That has also not been brought out.
In their chief, PW3 and 6 also stated that one is saying that one blow and another is saying that 2 blows, my lord. But back of, my lord, have a glance on the PW3, my lord. Categorically, you have stated that suddenly dealt blow by that wood on the back of Madhav, my lord. Back of Madhav, back, specifically mention back of Madhav. On the para 3, on the last person, my lord.
No, we are not on that. We are not for that. You see, one has stated in the chief examination, 1 blow was given.
My lord.
In the cross, you have elicited 3 to 4 blows.
My lord.
The other one says about 2 blows given.
My lord.
And doctor also says that that he has noticed 3 blows,
My
right? 3 injuries.
My lord.
And when a question has been asked whether these injuries can be possible if somebody comes in a very high speed and falls on this one, so
My lord, have a glance on the
he
cross
has-
examination of the doctor, para 4, my lord.
that is exactly what we are.
My lord.
He stated that it is not a fact
My lord.
that a person coming in a very high speed in a bicycle, if falls on the road by an accidental falls one, so his head in comes with a handle of the frame of the injuries would be possible. In such a case, the injuries would be either on the frontal side or on the back. All the 4 injuries at a time are not possible. So this is the thing he has stated.
My lord.
At the same time, you are not putting these suggestions to other witnesses, that there was such a eventuality where the deceased is likely to have fallen down from the cycle. If such a suggestion is not to other witnesses, how you are grooming at the end to the doctor only?
My lord.
You must have to make out a case right from the beginning,
My
all
lord.
through.
My lord. In this case, my lord, my humble submission before your honor, my lord. One is MO was not produced before the doctor, and another thing is doctor was not opined that
No,
the
you stick
sufficient
to the
was,
one that my lord is saying,
my lord.
that in an eventuality where the doctor has not adduced evidence to the effect that
My lord.
the injuries are not fatal in ordinary course of nature.
My lord.
What will be the consequence of that? What kind of
Have you gone through those decisions?
My lord.
So what have you found out? Suppose
That
a
was
doctor-
converted to 304 part 1, my lord, not 302, my lord. On case of
get those judgments?
GT Nanavati versus VN Khair, my lord, division bench.
No, you are.
And another also.
Our decisions
our
are
decision.
there. You
My lord,
go through it.
2022, my lord. My lord.
No, just find it out. Our decisions are there.
My lord.
The reason is that if you found that culpable homicide when it will amount to murder,
My lord.
culpable homicide has been defined under section 299.
Again, my lord.
And it will be amount to murder if it comes within any of the 4 clauses
My lord.
that is there in section 300.
My lord.
So,
This is the judgment of this honorable court, my lord.
just listen to and then just find out those decisions.
My lord.
If it comes within any of these exceptions, there are 5 exceptions,
My lord.
then it will be either 304 part 1 or part 2. So suppose it does not even come, the prosecution or the defense fails to bring it
My lord.
within any of these exceptions.
My lord.
That is
Then
exception 1 to 5.
My lord.
Okay.
My lord.
But still then, if it does not comes within those 4 clauses,
My lord.
that is clause firstly, secondly, thirdly, and fourthly,
My lord.
under section 300, that cannot be a murder. That
My
is
lord.
302 will not be there. That we have analyzed in some decisions and we have
My lord.
given, we find out those decisions.
My lord.
We can take up this matter on Monday.
My lord.
All right.
My lord.
So you can get it in the, if you give your click on the monopatra,
My lord.
sufficient in ordinary course of nature to cause death. Mr. Pradhan, you also go through this decision. 302, 304, part 1. The doctor has not given that any of the injuries is sufficient in ordinary course of nature to
My
cause
lord.
death.
My lord.
Hello? So what would be its impact? See, the clause thirdly, one of the thing is there that if it is done with the intention of causing the bodily injury to any person and the bodily injury intended to be inflicted is sufficient in ordinary course of nature to cause death. So this would be, it would come, then it would come under the 300 thirdly. Right? Other things are there, that intention part, secondly, how we have deliberated in the decision.
2024 January or February.
You just find out that decision. So
It was
that may help.
converted to 326. Converted to
We do not know. Just
Ma'am,
go to, it may be 304 part 1 or something like that. Just go through those decisions.
My lord. My lord.
So we'll take up this matter and the on Monday. Monday it will be in the topic. Put up this matter for further hearing on 6th of January 2020. Hello? So